of item number 35. It is in the down below the list. Last item in fact, Lordship, it is a review application. Lordship on the last occasion was pleased to issue notice, and today is the matter fixed for consideration of the interim prayer regarding stay of the impugned judgment, Lordship. So I am praying for that Lordship may be pleased to take up the matter maybe at 12:30 or at 2 o'clock.
At 2?
At 2, Lordship.
That will be better.
Highly obliged, Lord.
Much obliged.
May I
Yes.
please, Your Lordship, I beg to mention item number 23, my lord. Lord, this matter may be taken up after review application, my lord.
Number
23.
The prayer.
Item.
Yes.
Obliged.
May it please your lordship. I beg to mention item number 11 from today's list, my lord. I am appearing on behalf of Mr. B. Chakrabarty, my lord. My lord, matter may be passed over for the day, my lord, and may be fixed after a week, my lord.
Then put it.
I am highly obliged, my lord.
May I please, Your Lordship? Lordship, I beg to mention item number 24 of the daily list. Lordship, matter may be adjourned for today, Lordship. Consider after 3 weeks, Lordship. Twenty-four.
$29.
Much obliged.
May I plead your lordship? Your lordship, I would like to mention item number 23 for examination, your lordship. 20. Obliged, your lordship.
May I please, Lordship? Lordship, I beg to mention item number 17, Lordship. Lordship, kindly matter will pass over for the day. Much obliged.
No representative on behalf of the petitioner. Let's talk about. I'm sorry. The application or application.
Lordship, our presence may be recorded.
But next CGC is there. The safe purpose. Yeah. You are for. What's a good name? H. H.
May I please, your lordship?
Contested case, my lord. The important order start from page number 52. In this case, my lord, father deposed on behalf of the petitioner, my lord, but the tribunal did not, without discussing the evidence of father, my lord, he has been declared as fraud. What is the link document between you and your father?
It's
What
evidence
is the
of
link
father.
document?
Evidence of father, my
Evidence of father.
lordship. It's number 46. The evidence of father has been not been discussed by that tribunal in the order.
Where is the written statement of the prostitute?
On page number 32.
voter list.
Voter list, my lord, 1965 at page number 21. In the name of grandmother. 22 page number Renuvala. Then my lord, 89 as page number 25 and 26.
That figures the name of one Nitai. Where is Bolai?
My lord, entire family is not in the voter list. They may be in separate house. In 89, the father of the petitioner and grandmother appear. Then 97 father, 2010 father and wife of the petitioner.
Your name of your father figured only in the voter list of 1989.
89 and subsequent, my lord. First time 89.
Why not prior to that?
In 89, my lord, she is 25 years.
So
Before 89 was he.
before 89, there were elections at 85. There was election at 1985. Why your father's name did not figure?
In 85, he may not be, my lord, enrolled.
In your written statement, you have stated para 14, page 33. The three uncles, right?
Lordship. Nitai,
One is-
Polai, and Kanai.
Nitai De, Kanai De, and your aunt Jaya De. Now, page 26. One. One. We have to take up this matter some other day because my sister is having a different file. The consent file of Binoy De is not before her. Okay? Two one will over. One to one to over one. Separate.
it is seen that the part two file relates with WPC number 7621 of 2023. Whereas the part one file relates with WPC number 7612 of 23. In bracket Pinoy de alias Pinoy de versus intermediate athlete. Listed the item number 2 before this code. Resist this accordingly to the need. List the matter on. Now like click put it. 10th of January. So put it.
Always. Maybe lordship, my lord.
Yes, Mr. Ali.
My lord, kindly see input note at page 78, next are 18, my lord. And the relevant part, my lord, page 80. Here the petitioner annexed the document, my lord, 76, 70, 66, 70, 93, 97, 2010, and 1997, 2010, and 2016. The 97 petitioner father's name appear continuously, my lord, up to 2006. And 97 petitioner name also appear with his father and brothers. But in the said bodily D was inserted, my lord. And here's, my lord, the petitioners are two brothers, DW2 and DW3, and the Gaura also deposed the honorable courts. And they are claiming only Gaura, my lord, reject only on that the certificate stated state emblem was issued. That ground, my lord.
Just tell us one thing, Mr. Ali, since we've been doing this successful. Let us assume a Gaura appears
Yes, ma'am.
and adduce evidence for a particular proceeding.
Yes, ma'am.
That I have issued this certificate. I know he is son of that. Now, mayor saying from his knowledge, will it be enough or it is sufficient that it has to produce the relevant records to show?
His petitioner father and brother name are reflecting voter list along with
See,
petitioner.
that is there.
My lord.
Now, even you, without being authorized by any governmental authority, you can issue a certificate as a council from the voter list, right? Will that be enough? Because a Kaumpura is a responsible officer to have the names of the people of his charge, whatever, he may be in charge of one village or two village or three,
Yes, my lord.
right?
Yes.
But thing is this, mayor making a statement or giving a certificate just on the basis of the voter list
Yes, my lord.
without being verified from his records, will that be enough to show that the lineage of anyone, the linkage between the prosody and his father or her father or her?
On the basis of the my lord, he used voter list, my lord.
Because that is the reason.
Yes, my lord.
And the
he also
voter list, there is no voter list. Normally what we have seen, the voter list showing the prosody and his parents.
Yes.
There are few. It is not that there are not. There are.
Here, my lord.
But thing is this, there has to be a voter list showing the prosody along with his or her parents
Yes, my lord.
in the concerned village.
Yes.
Now thing is this, the Kaumburas we have seen, or the certificates issued by the Gaon Panchayat Secretary. They are
Yes.
issuing certificates.
Here, this case, my lord, petitioner and petitioner father name same voter list name.
In which year?
1990, first time. And
How old was the
20 years, my lord, at that time. But here, my lord, case is that the two voter list is annexed, my lord. One is the certificate copy, petitioner 97 is D voter, so certificate is not is. So we also photocopy also, my lord. Both are we annexed here, my lord. 97 onward. And petitioner brothers also, my lord. And my lord, order also reflect the regarding my D voter, my lord.
your translation is wrong. Look at page 75. Not translation, retyping.
It was typing, my lord.
You should have checked. Look at the cross. Today I have produced my appointment letter as Gaunbura, joined in the year 1970. And look at page 76.
I have issue.
After cross, the first line after cross.
I have issued this certificate in the name of Insar Ali as an
No. Read the after cross.
Today.
Hmm.
Today I have produced my appointment letter as a Gaubura and joined in the.
Now come back to page 76. Turn the page and see 76. After cross, what is written there?
Today I have not. Sorry, my lord. I'm sorry. That part, madam. Sorry. Extremely sorry.
Mr. Ali, the trust between the side and this side is too much.
I'm sorry, my lord.
Don't
Actually,
let it
it
go.
is not
let it
sick,
go.
so
This trust is very important.
yes, my lord. I'm sorry, my lord. Sir. But other parts, my lord, I have noted D voter. Here, yes, actually not properly. That is the problem, my lord. So I'm sorry, my lord. That part, my lord.
Okay.
This is 1980.
VPNX করা নাই। ভালো কথা না।
1981 में नहीं।
Village of 97 of people. NX 9. ये तो भूल गए
We are.
ये तो भूल गए 1918 लिखे गावराचे 97 1918 लिखे ये फोटो ट्रिब्यूनल एपीटी
Or Mr. H. Salil and counsel appearing for the petition. Any CGC here? I'm Mr. H. Puli, Petty Counsel. SCI, correspondent. MSK Verma, Petty Counsel, Department of the Six. P. Verma, Petty Counsel. Sorry, permanent pocket. Additional children from pocket. After hearing the petition, considering the evidence deduced by him, learned member of Fairness Tribunal for Pesha in case number FT within bracket 50 bracket 2. Please take your seat, Mr. 7 of 2018 within bracket reference FT case number 97 of 2017 by the impugned final order that 10/08/2023 appoint the petitioner to be a foreigner under the Foreigners Act 1946 who had illegally entered into territory of India, Assam, on or after the cutoff date of 25/03/1997. Dissatisfied with the state opinion that the circumstances of the depot, the petitioner has preferred the certificate on 22/12/2023. Notice returnable dated of the depot. Petitioner also repeated extra copies. Mr. Architect and FTS, TYSJ, or resolution for Mr. AIR, and it was let me put MSC performance getting out for the on or before 9 Petitioner shall take steps for service of notice of direction number 4 by registered post. Subject to taking steps on the responses and his appearance before the Superintendent of Police on or before 19. Not correct, 22nd. Call for the record.
Hello, Abhilash.
Mr. Ali, correct that
Yes.
paragraph.
Yes.
By hand in all the methods, both the methods, also the service copy. Putting your initiative.
My lord, today itself, my lord.
Today it will do it.
May I plead your lordship? Lordship, your lordship, we will find the impugned order at page 71.
Mr. Sharma. In fact, once you or Mr. Pying places judgment regarding the land documents normally placed in evidence before the tribunal by the prosecutor. The validity of such land document was discussed in that particular. Do you have?
I think one is Munwara Biwa lordship.
One stand because earlier coordinate benches of the matters have taken to view that constitution view because of the revenue being received, up to date revenue being received.
Yes, Lord.
Secondly, the judgment of the Honorable Apex Court. It is only to focus that name being there is only, we have passed a judgment few days back, where we have discussed that particular issue, right? And then we want to know which are the other judgment where this coordinate benches have taken into consider all these and because there have to certain conditions to be fulfilled. And in one of the judgments, it is said that land document will not be enough to prove the linkage between the prosody on his parents.
Okay.
That you need to clear.
Yes,
Because there are 2, 3 specific judgments of the Honorable Apex Court regarding that. Right? And then kindly see, you will be having 2 days holiday for Saturday, Sunday. There are judgments to find out.
Copy of Jamabandi only, basically only for fiscal purpose, Lordship. No,
Indicating that they have to pay the land revenue in time, that much. That's what the Apex Court have to say.
Lordship, I will provide.
Find out. There are judgments, specific judgments, you may not be able to make the research, and there are judgments, where the land document will not be enough. Probably of Honorable Justice U. Mia or Monojit Mia, somewhere there are judgments. Because once I remembered reading this judgment where Justice M. Bhuya along with Justice P.K. Teka have consulted cases in their have delivered. Find out. Itu dia. There are different issues like, as you know, unauthorized occupants of government land.
Yes.
In most of the cases from the records we have seen, while making such investigation by police, they will write occupying government land unauthorized.
Yes.
So anyway, those are different issues. These issues are discussed in 2, 3 different cases.
Yes.
Try to find out.
Yes, Lord.
Not now itself, but have it,
Yeah.
because these are the issues which are need to be because the
Yes.
validity of a land document, whether it is SITA or a Jamabandi, to what extent its reliability for the proof of lineage or the linkage between a prosody and his parents or not.
Yes.
J. Ahmed. H. Kuli, right? Full name? Let me put it in that. G. Sharma. And me also put it. P. Sharma. Member, Warner's Tribal, Kamru, Indicate Network. Start. What? In application number 276. Public. Final order 25/03/2023. declare the petition appear for any public legal matter. The report letter of post the declare the document. That's it on 21/12/2020. Appear before Deputy Commissioner of Police within bracket order. Guwahati honor before. Good, order. Next steps on the respondent.
With your lordship's permission. Lordship, I am for the petitioner in this matter. This matter is about finalization of provisional pension that was sanctioned to the petitioner about 17 years ago. The petitioner has served as a science teacher with Victoria Girls Higher Secondary School, Dibrugarh, for over 15 years. But your lordships, the provisional pension that was sanctioned to her at a very nominal rate is yet to be finalized. May I bring your lordship's kind attention to page number 27 of my petition, your lordship? The respondent authority, Director of Secondary Education, writes that as in 1, 2, 3, 4, 5, 6, sixth line, as the matter is under your jurisdiction because the teacher concerned is an assistant teacher who served for more than 10 years. She was allowed to go and on voluntary retirement services. Now, your lordship, by office memorandum
Why
dated,
this is before division bench?
this was listed under your lordship.
What you have to do? Should be before single bench. Matter relates to pension.
May I?
Just to. Matter relates to non-disbursement of the final pensionary benefit to the petitioner. He was a teacher of which school?
Victoria Girls Higher Secondary School, Dibrugarh.
Assistant teacher or a subject teacher?
Assistant teacher, but she was teaching science all throughout her tenure.
Science teacher of Victoria Girls Higher Secondary School. Who retired from service. When did she retire?
She retired on 1st of June 2006.
Cannot be 1st of June 2000.
Your Lordship, date
to
of,
be 31st of May or
Lordship, page,
30th of June.
I apologize,
Should be 31st of May.
31st of May.
Anyway.
Your Lordship, with my humble submission is on page 31, 30. It is a little
Next.
clumsy.
From the checklist itself, it is clear the matter relates to civil events too, with code number 10017. And the registry shall release this matter before the appropriate bench.
Great for your Lordship. I'm appearing for respondents, Your Lordship, for secondary education.
Ada,
PDAS.
sorry, Ada, pending call. That's
Deep-
the pending call.
Great, deeply amazed.
Inquiry Maritima protected. No representation of. To name of the council president. Pardon, Mr. Ram. G. Sharma, Delhi Council. Six students. H. Kulip, Delhi Council. Election. And Mr. P. Sharma. Additional children were thrown for that. List after 2 weeks on a date.
Thank you.
The part 2 file. To 7612 of 2023. Whereas the part 1 file relates to WPC number 7621 of 2030 listed as item number 7. Registry shall do the needful. And let the matter. Place the matter on tail. Correct. Any case take. Okay, take. I go to the okay take. The other part, my sister file is different.
Okay.
That's the reason it will come up. Yes, please.
Lordship, in this matter, the petitioner was earlier declared an Indian, and later on again a notice has been served upon him. The earlier order is at page 29. Detailed opinion was being passed. The same has been informed, notice has been issued, the same has been informed to the same court, the court number 3 of Nagaon. But the case, the petition was being rejected and asked for the fresh trial again.
Mr. Sharma, there are two judgments, one by Justice
Yeah.
M. Bujar Burwa, right?
Yes,
And there is also another judgment prior to that by Justice Bhuya or Justice Manojit Bhuya.
yes. Not the recent judgment, two judgment has been passed by Honorable Justice M. Bujapura Lordship.
Prior to that, there are two, I think. So there is one by Justice, either by Justice U. Bhuya, headed by Justice U. Bhuya or by Justice M. Bhuya,
Amina
Where-
Khatun.
where the discussion of evidence is required. Just mayor making a statement of the evidence is not enough.
Yes, Lordship.
What are those?
Yes,
what are
Lordship.
do you
I will
have those
provide,
judgments
Lordship.
with you? Or the,
Yes,
give us the numbers.
Yes. Right.
Because in one of the judgment, coordinate bench have discussed that even if it is not discussed, that can proceed to the second matter.
Yes, Lordship. Hold it time.
You have to prepare a chart,
Yes, yes, Lordship, I have, Lordship.
giving the numbers, giving numbers, whether the matter relates to the certified copy of documents or whatever, land documents.
Hmm.
That will help you.
Yes, Lordship, one is 251 of 2023. 251 of 2020, Rafiqul Islam, Lordship.
In one of the case I have read, I haven't recorded the number. Justice Yu Bhuya dealt with the matter, where the second notice was issued. Because earlier, if it is second notice was issued state, but in that particular matter, second notice do issued. And it was brought to the notice of the tribunal by the proceeding. But in that case, the matter went along with the tribunal went and declared in the subsequent case, just like in the present case, declared the proceeding to be a foreigner.
Yes, Lord.
There, his lordship have a detailed discussion in which circumstances the tribunal
Hmm.
can look into it. And if it is found that there is no proper discussion of the evidence,
Yes, Lord.
in that circumstances, it has no value,
Yes,
which has been reiterated by Justice Bujarbura in his last two judgments.
yes, Lordship. One is I have provided, Lordship. And
251.
there is, yes, 251 oblique. Okay. There is another judgment, Lordship. I provided. This is Rafiqul Islam, 251 of 2023. FT group. আমার FT group.
Give it to us later on.
Yes, Lord.
There are one of Justice Monojit Bhai and Justice P.K. Deka discuss about it. The others, I believe, Justice Yu here, his lordship also consulted this, have deliberated in this issue.
And
Yes.
Koteshwar Singh, justice also given an judgment in this regard. Koteshwar Singh.
There is.
After the judgment, this judgment.
But what we have noticed, neither the petitioner nor the respondent placed these judgments excepting one, which we are discussing in the full bench.
Shamsul Haq versus Union of
That we are
India.
discussing in the full bench. Heard Mr. S. Ahmed, Council of both the petitioner. Mr. Z. Sharma, Standing Council from Department of Assam. 2 and 3. Also heard Mr. P. Sharma, Petitioner Chamber of Assam for resolution number 4. Mr. H. Standing Council Election Commissioner of India for resolution number 6. Being referred by the Superintendent of Police Order, Nagaon. In bracket police case number 125 of 2015. Learned member of Fairness Tribunal, Court, Nagaon, Assam. Hearing the parties including considering evidence used by the used by him. In petition number 613 of 2013. By the impugned order dated 29/08/2023. Who find the petitioner to be a foreigner. No, you are agree with this order of,
Of the latest judgment that is given by the FT 3
29/08/2020.
29/8/23.
All right. It is stated by the petitioner that in an earlier proceeding, being FT case number NFT within bracket number 336/2016, arising out of police case number F.T.520/2005, learned member of Foreigners Tribunal, Heart Nagaon, by the order dated 07/12/2016, opined the petitioner, opined that the petitioner is not a foreigner of the scheme of 01/01/1966 to 25/03/1971. However, the same tribunal, i.e. Foreigners Tribunal, 3rd Nagaon, Assam, in petition number 613/2023, in number NFP, bracket close number 3, FT 571 of 2000/2016, arising out of police case number 125/2015, being referred by the student of the order by the impugned order dated 29/08/2023. Opined that a said proceeding, i.e. case number 517/16, shall be continued in spite of the earlier finding of the tribunal dated 07/12/2016 of the above. Agree with the said order dated 29/08/2023, passed by the Learned Member of Foreigners Tribunal, Assam, in petition number 613/2023, in number NFP 124 in bracket number 3, bracket close FT 517/16. The petitioner has filed its petition on 21/12/2023. Frame amongst others to set aside the said order dated 29/08/2023, passed by the Learned Member of Foreigners Tribunal, number 3rd Nagaon, in application number 517/16, arising out of police case number 155. Call for the records of case number NFT within bracket number 3, FT 517/2016, arising out of police case number 125/2015, from the office of the learned member of Fairness Tribunal Third in Nagaon, Assam, wherein the impugn order dated 29/08/2023 was passed in petition number 613 of the 2023, as well as the records of FT case number NFT in bracket number 3 bracket close 36 of the 2016 within bracket police case number F30.520 of the 2005 disposed of on 07/12/2016, also from the office of the learned member of Fairness Tribunal Third. Registry shall list this matter for motion immediately on receipt of the the appointments into records from the office of the Fairness Tribunal Third House.
Lordship, under cases, Lordship WBC 1248 of 2023. 1248 of 2023. Passed by Honorable Justice M. Jobra. And earlier one is Lordship WBC 7339 of 2015. Lordship Amina Khatun's case, Lordship. 7339 of 2015. Decided on 19/4/2018 by Honorable Justice Ujjwal Bhuiya and Ajit Borthakur.
There is another case subsequent to that where Justice Monojit Bhuiya sitting with Justice P.K. Dekar. There they have discussed this issue. And also there are certain judgments where along with the same bench, Justice Monojit Bhuiya and Justice P.K. Dekar discussed with the land document.
What's your entry?
We have called for the record. Nothing to worry.
The operation of the case may be stayed, Your Honor.
Nothing to worry. We have called for the record means where the tribunal will proceed.
Obliged.
Yes, ma'am.
May it please your lordships. Lordships, in this case, this is second time approach before this honorable High Court lordship. Earlier order dated 31/21 lordship. The petitioner had approached before this honorable High Court by filing a writ petition being WPC number 2563/21, and the same was disposed of by order dated 7/6/23.
Kindly tell us the date of the order and the annexer that you have annexed.
Earlier lordship.
True.
Yes, lordship. Lordship, earlier page number lordship 103.
103. is the order of the tribunal. What is the order of the High Court? Passed earlier, you have prepared a writ petition.
Yes, lordship. 109 lordship.
109.
Yes, lordship.
What was the direction issued?
Yes, lordship. Tribunal to arrive at a factual determination whether the village lordship, 3 village, Gunaibori, Uralkata Pathar, and
What was the direction issued?
lordship.
Para 6.
May I read lordship?
Please.
We are not expressing any view on the said submission, but remand the matter back to the Fairness Tribunal number 5 Morigaon to arrive at a factual determination whether the villages Gunaibori and Uralkata Pathar and Veloguri being adjacent villages, the names are used interchangeably in the voters list of the 3 villages. For the purpose, the view of the Election Commission of India be also obtained by the tribunal. The state respondents in the Home Department through the Superintendent of Police border, Morigao may also make their own verification. If so advised, and thereafter submit a report before the tribunal. If it transpires that it is in fact the voters list of the same village, although in 1993 the name of village Uralkata Pathar and Veloguri may have been used, appropriate order may be passed by the tribunal in as much as otherwise the information contained in the voters list as regards the petitioner and his father appears to be prima facie consistent. Thereafter, thereafter, Lordship, the petitioner appeared before the learned tribunal on 13/7/2023. And Lordship, inquiry report also I have annexed, and circle officer also issued a letter, deputy commissioner also issued a letter, and the circle officer and Lordship, kindly see page 123, Lordship. May I read, Lordship, please?
Just a minute. Where is the certificate of the village headman?
Lordship, kindly see page 121. With map, Lordship, Veloguri, Gunaibori, and Uralkata Pathar is the same as adjacent village. Deputy commissioner issued this letter.
Where is the illegality in this order?
Lordship,
Where is the illegality in this order? Up to page number 131.
yes, Lordship.
The last paragraph. Kindly read
1 to 132, Lordship.
131.
Yes, Lordship.
It starts at the last paragraph.
Yes, Lordship.
Kindly read.
Yes, Lordship. Thereafter, in pursuance of paragraph 6 of the High Court's order, reports were sought from Election Office Morigao as well as SPB Morigao as to find out the fact whether the villages Gunaibori and Uralkata Pathar and Veloguri actually has to be Veloguri are adjacent villages or not. Thereafter, the reports were received from Election Office Morigao as well as SPB Morigao in respect of present status of those villages mentioned above, which are enclosed with the record as Mark 1, Mark 2, and Mark 3. The Circle Officer of Lahorighat Revenue Circle of Morigao District said in its report that village Uralkata Pathar, Gunaiburi and Veloguri, which is mentioned as Veloguri, are adjacent villages under Lahorighat Revenue Circle. The SPB Morigao also stated in his report, that is in Mark 3, that the villages Uralkata Pathar, Gunaiburi and Veloguri are all adjacent villages under Lahorighat Revenue Circle. But in their report, the circle officer as well as SPB Morigao has not said that all the villages are separate revenue villages. They had only said that all these 3 villages are adjacent villages. But if the area map of those villages enclosed with the report sent by the circle officer Lahorighat SPB Morigao are verified minutely, then it is found that all these 3 villages are separate village revenue villages, and their serial numbers are also different, such as so and so 909700, 909800 and 90990 for Veloguri, Gunaiburi and Uralkata Pathar respectively. The above mentioned differences in respect of these 3 villages, which is found from the reports of Circle Officer Lahorighat and SPB Morigao, clearly disclosed that the voter list of 1993 of village Uralkata Pathar and Veloguri and the voters list of 1965, 1970 and 2010 of village Gunaiburi are not of the same village. Under the above observation, I say that the OP has submitted voter list of different villages, and though the OP has tried to prove all these voter list to be his own and thereby has tried to prove his Indian citizenship. Yet it is seen that all
You
those
relied
above-
on the certified copies of voter list.
Yes,
Which village?
1965, 1970 Lordship. 1965 page number Lordship. Kindly see.
Page number
Page
23.
number 23 Lordship. 23, 25.
Now, who is your father here?
Father Lordship Ali Hussain.
Your father.
Yes, Lordship.
He is from Gunaibari.
Yes, Lordship.
Then
Then 1970 Lordship, page 25.
she is also from Gunaibari.
Gunaibari Lordship.
Then
Lordship 1989, page 33. Here is also Gunaiburi, Uralkata Pathar, Veloguri and Gunaiburi. 1989 Lordship.
1989. Now,
Lordship, voter list 1997, also page number 37, Lordship, Gunaiburi village. 2005, 2010, also Gunaiburi Lordship. Only discrepancy is Lordship, voter list 1993 and Gunaiburi, Veloguri and petitioner is a teacher, Lordship. Petitioner date of birth is Lordship 1/6/1968. Earlier Lordship he had exhibited so many documents. The SSLC pass Lordship. I have also annexed admit card. All his academic documents, Lordship.
For the first time,
Lordship,
when the name of the petitioner figured in the voter list.
Lordship. This 19. And this for Roman voter list 19. 1993 Lordship, Anisur. Petitioner is Anisur Rahim.
How old was he at that point of time?
Yes, Lordship. There is showing 24.
24.
His date of birth is 1968.
Hmm. So
His date of birth
his
is
name should have been in
1968.
the voter list of 1989,
1989, page 33.
is not it?
33. Page
Where is your
33.
written statement?
WS Lordship.
Have you annexed?
Yes, Lordship. WS Lordship, page 59, Lordship. Married.
Just a minute. Please come to page number 33.
Lordship.
Serial number 744.
744. Yes, Lordship.
Who is he?
Anisur. Anisur. This is petitioner lordship, but his name is wrongly his spelling is
You have not mentioned in your written statement anything about Anis Doul.
Ani-
You have mentioned about Asadur, saying that his name is the younger brother, his name figured along with you in the voter list. Now, who is this Anis Doul? In your written statement, you have not mentioned anything about that.
Tool. Then rock. Tool.
Now, just come back to
Lordship.
the voter list of 1993,
Yes, lordship.
page 35.
Lordship.
Who is this Khudeja,
So this is the mother of the petitioner, lordship. Oh,
mother of the petitioner?
sorry, lordship. Mother is Kodorjan. Kodeza is the this is the wife of petitioner.
Wife of the petitioner.
Yeah.
Good. Now, page 37,
Lordship.
serial number 689.
689, lordship.
Khudeja Khatun,
Yes, lordship.
known as daughter of Ali Hussein and a male.
Wait, Ali Hussein. Wait.
Come to the subsequent voter list, 2005 at page 39.
2000. Kodorjan. Ali Hussein, father. Kodorjan,
Khudeja
mother.
Khatun, name not there.
Here is father, mother, petitioner, and Asadul is another brother.
Then
of
again at page 41, 2010 voter list.
Lordship.
Khudeja
Anisur.
Khatun is not there.
Yes, here is petitioner and he's another brother with brother.
At page 43, voter list of 2016.
16. Anisur petitioner, Asadur brother, Khudeja here is wife, and Ruxana is one daughter,
Again
and
name of
Roshida.
Khudeja Khatun,
Yes, Lordship. Khudeja.
soon. Mr. Kuli. The voter list placed before the tribunal, whether genuine, see what we have been seeing here consistently.
Lord.
If you read section 76 of the Evidence Act, that will clear. Here at page 23, if you see the voter list. Norma. Read section 76 carefully and slowly. Come this side.
My lord, section 76 certified copies of public documents. Every public officer having the custody of a public document which any person has a right to inspect shall give that person on demand a copy of it on payment of the legal fees therefore, together with a certificate written at the foot of such copy that it is true copy of such document or part thereof, as the case may be, and such certificate be shall be dated and subscribed by such officer with his name and his official title, and shall be sealed whenever such officer is authorized by law to make use of a seal, and such copies so certified shall be called certified copies.
So there has to be name of the officer.
Yes, madam.
You see?
Yes.
Name of the officer authorized,
Yes, my lord.
right?
Yes.
Along with the seal.
And his official title and shall be sealed.
His name should be there.
Yes, my lord.
Then the official title should be there. And then the seal.
And shall be sealed.
Now come to page number 23. Look at page 23. There is a word, there, the seal is there, certified to be true. Seal, election officer, Nagaon. The name of the person is not there. Then come page number 25. On the right hand side, you will see. Come to page number 33. Similar, let's take the page number 23. Same date. 25th of September 2019. Page number 35. Same date, 25th of September 2019. The name of the officer concerned who issued is not available in any of these voter list as certified copy placed before the tribunal. Page 37. Page 39. Page 41. Go on like this. Page 43. Now you have just read section 76. Can we consider his voter list with certified copy of voter list of the respective villages? Whether it has been issued in compliance of section 76 of the Evidence Act.
I don't think so, man. I don't think so, man.
You don't think so? You can read section 76 and you can see from there.
Because the name of the certified officer
The authorized
authorized
officer
certified
to
officer.
issue certificate
Yes.
or the certified
It's
copy
not
of the
here.
voter list. It's not there.
Yes.
You are the election commission. You know.
I have to take it for instruction.
We are also indicating to you, whoever is authorized to issue such certified copies, unless the full name, because section 76 is very specific. Mayor initial will not do. The name of the officer authorized to issue this copy, the public document, along with seal. Just mayor in initial will not know who is the name, because if you see on the right hand side of the certified copy, the initial will mostly file on the name of Arun Chandra Bhuiya or Pratik Das with the different periods that now come. Those are the original certificate. Originally in the record, the elected copy, the total. Now, certified copy again have to be issued by a person authorized with his full name, with his signature. That's it. These are missing here. This is not only the one case. Right? So you have to do the full whomever they have issued. My lord. What's your good name, ma'am?
Hasina.
Ahmed
Hasina.
Had
Like
Mrs. H. Ahmed,
HM.
led counsel for the petition. Earlier, learned member Furnace Tribunal 5th, Morigaon, by the order dated 30/01/2021, in case number F.P. put in bracket capital D 884/2017. I'm being referred by the Provincial Police Border, Morigaon. After hearing the parties, including the petitioner and the evidence adduced by him, appoint him to be a foreigner under the Foreigners Act 1946. of post 25/03/1971. Agree with the said finding. Dated 30/01/2021. The petitioner preferred a writ petition saying WPC number 2563/2021. And the court, after hearing the parties by order is 07/06/2023, remanded the said FT within bracket D case number 884/2017 to the learned member of Fairness Tribunal, 5th Morigaon, for reconsideration of the case pertaining to the voter list of villages Ural, URAL, next word is Kota Pothar, KOTAPATHAR, and Belguri, BLGURI. As well as village Gunialbari,
Gunaibori. G-O,
Gunaibari,
Gunai.
GUNAIBARI. Pursuant to this direction of the High Court, dated 07/06/2023, passed in WPC number 2563/2021. The learned member of Fairness Tribunal, 5th Morigaon, after obtaining the report from the Election Office Morigaon, Superintendent of Police within bracket border Morigaon, and the Circle Officer of Lahori Ghat Revenue Circle of Morigaon District, came to the finding on obtaining the report, and perusing those reports, considering the same, came to the conclusion that the said three villages, namely Ural, Kota Pothar, Gunaibori, and Bheloguri, are three distinct and separate revenue villages having their respective numbers and came to the conclusion that the voter list of 1993 exhibited by the petitioner relates to villages Ural, Kota Pothar, and Belguri, whereas the voter list of 1965, 1970, and 2010 exhibited by the petitioner relates to village Gunaibori, and that those three villages are not at same village. And thereby, the petitioner failed to prove his citizenship, and by the impugned opinion dated 25/10/2023, asked in said case number F dot P dot within bracket T 884/2017. The learned member of Fairness Tribunal 5th, Morigaon, opined that the petitioner is a foreigner under the Foreigners Act 1946 of post 25/03/1971. Agree with the said opinion dated 25/10/2023 of the firm of the learned member of Fairness Tribunal 5th, Morigaon, Notary Depot. Petitioner filed this. So notice returnable by 8. Before that, will like or then no. These are not that I thought you would. Two and four. Each are my articles are not for that. It's fully that I thought. Election of it. For five. Therefore, the notice returnable as per the step 5. Yeah. Offering it to tax. Petitioner shall accept for the qualified certificate. Copy of the architecture. Deputy Solicitor General. for the opinion. Petitioner shall accept for the providing corrected for it. 09 subject to taking steps in the rest of some water on the type process and on parents and on the parents before the Superintendent of Police Dr. Morigaon on or before 22/01/2020. Yes.
May I please your lordship? My lord, this is a contested case, my lord. The father's name, my lord, in the 1970 voter list, my lord. If I may take you, your lordship, to page number 35, my lord. Jainal, son of Kajal, is the father, my lord. Village Bhakuamari.
Mr. Puli, do you have a copy of the writ petition? You don't have. Look at from Mr. Verma. Come to page number 36. Down below, you just see. You can read vernacular,
Yes, my lord.
just see. Hoityo Pramanito Nokol. On the right hand side, down below,
Yes, my lord.
and the name is there. Sri Tej Prahad Ural.
Yes.
Nirbachoni Bikoya Borpeta. That's what as per the section 76.
I got.
At the top, you will see the date of the application. Sarihat
8/7/2005.
2005, then Hat 2005, and Hat 2005. So applied, ready, and furnished. Anyway, thereafter, these things are different. At page 37, you'll see the electronic voter list. Where is your link document?
My lord, page number 38, my lord.
Hmm.
It's 1997 voter list, my lord. 35, my lord. Sorry. Sorry, your lord.
Which voter
19
list?
Yes, it's 39, 38, 39. Page number 39, my lord. Annexure 7, 1997 voter list, my lord. Gaji Ali, son of Jainal. Starts from here. Then we have 2005, 2010, my lord. After 2010, he was marked as a D voter. This starts from here. Same village, my lord. Same village.
You are Gaji Ali.
My lord, Gaji Ali.
How old are you?
He was 25, my lord.
Your name figured for the first time only in the 1997 in the voter list.
My lord,
I'm not sure if this was the first time, but this was the first document that was annexed before the exhibited before the tribunal, my lord.
Where is his written statement?
My lord, written statement is page number 18, my lord, annexure 1.
That is the only linked document.
My lord, no, then we have 2005, the next annexure after 1997. It is page number, my lord, 41. 41, my lord. This is also from the same village, my lord. This is 2005 voter list.
After 1970, the name of your parents figured in the voter list of 1985.
85, my lord.
What happened in between?
My lord, those documents were not exhibited before the tribunal, so we could not annex it here.
Yes, Mr. Sharma, what do you have to say?
My lord, here lordship, basically link between father and grandfather was not established lordship. And prior to 1970 lordship, there is no document. Apart from that lordship, from 1970 to 1985, there is no continuity lordship. So his father of the petitioner is 32 years. In the year of 1970, his name should be there in 1966 voter list. Yes, 36 lordship.
Maybe he might definitely, let us assume in this way. He came to India prior to the cutoff date. His name is there, that is why in the voter list of 1970. Then
Apart from that, Lordship, from 1970 to 1985, Lordship, there is no continuity, Lord.
is it required?
Yes, Lordship, as per section 6A2.
There should be continuity.
Yes, Lordship.
Whether this FT case of your brother,
There is a case which will be listed in the next week. We have filed it together, my lord. Abed Ali is the brother. He has also been declared as a foreigner, my lord.
whether that petition has been numbered?
We have filed on the same day. I was presuming it will come together, but it did not come together. We have filed it
Verify,
together.
then we'll have both the matters together
Yes, my lord,
next week.
my lord.
Okay.
Yes, your
That will
lordship.
be better for you, better for the court,
My lord, my lord.
because same record will help, will be.
Yes, your lordship.
In the other matter also, your brother has been declared to be a foreigner.
My lord, my lord, my lord.
So against that, you have filed an.
Yes, yes, your lordship. We have filed on the same day, my lord. He also deposed before in this case as DW2.
When did you file?
Uh,
22nd of December.
my lord. Yes, your lordship.
Okay, we'll have it on 21, 19th or
Little
if
early
you
before vacation, my lord, because that case will come up, my lord, now. Considering the fact that we filed on the same day.
12th of
12th,
January,
my lord.
12th January.
12 January, my lord.
The prayer of the consultation. Section 12.
Deeply obliged.
Yes, Mr. Day.
My lord. My lord, in this case, my lord, it is the fact that the petitioner father came from East Pakistan, my lord. But in the year 1951-52, my lord, it is reflected in the judgment also, my lord. And
Whether proceeding, the petitioner could prove, yeah, her linkage with the petitioner or not, the father or not.
my lord, for this, my lord, school certificate has been produced, headmaster was called for and headmaster also given evidence. And the conscious certificate is also given, my lord, conscious secretary, insert secretary has came and given evidence. And moreover, my lord, his elder brother given evidence, my lord, at DW2. My lord, all this, my lord, proves that, my lord, petitioner is the daughter of late Horidon Roy, my lord.
In your written statement, you have written your father's name is what?
My lord,
Horidhan Roy or Himanshu Roy?
my lord, that in the cross-examination, that is corrected, my lord. By mistake, it was stated, my lord. In the cross-examination, she stated that I wrongly stated, but my father's name is so and so, my lord. In the cross-examination, it is corrected. Page 41, my lord, paragraph 2.
Qatar not knowing about the service rendered by her father. How can it possible?
My lord, he has, my lord, two wives, my lord. One remain in Agartala and another is in the Makhan Bosti.
Then how he was having the
My
job?
lord. And in 1954, my lord, he was joined in service, the petitioner's father. And the petitioner was born in 1967. My lord, there may be some, yeah, my lord.
Which is the link document?
My lord, one is school certificate, my lord. Page. Hmm? Page 22, my lord. 23. Annexure P2. My lord, his elder brother also given evidence, my lord, at the TW2, my lord.
Have you read the certificate? Can you think that, do you think this is the certificate? Huh? This certificate is having the national emblem. Hmm? Now,
My lord, his elder brother given evidence, my lord, that may be taken into account, my lord. Is the elder brother, that is Kalipodo Rai, page 51, my lord,
I've read that. Not that it's
the relation.
Have you annexed the written statement?
My lord. Written statement, my lord. Page. Hmm? 37, my lord. Page 38 is the Barnacular, my lord. Page 38, annexure P10. They are three brother and sister, my lord. Paragraph 3. Kalipodo Roy, Shunati Roy, and Vulu Roy. In the 1970 voter list, my lord, his father's name shown.
Please come to page number 38A.
38.
Got it? It's in vernacular.
My lord, paragraph
9.
9, my lord.
Kindly read.
এই গোচৰৰ বিপৰীত পক্ষৰ পিতৃ মৃত্যুবৰণ ঢুকাইছিল 17/3/2017 চনত চৰকাৰী চাকৰি কৰি থকা অৱস্থাতে ঢুকাইছিল।
Good.
এই গোচৰৰ বিপৰীত
No, no,
পক্ষৰ জন্ম
it's not required.
My lord, is the death certificate, I
minute,
have
just a
annexed
minute,
the death
just
certificate.
Come to page number 48. Got it?
48, yes, my lord.
6th line from bottom. This is the cross of the petitioner. 6th line from bottom. The line starts with DSO.
মোৰ পিতাই চৰকাৰী চাকৰি থকা অৱস্থাত মৃত্যুবৰণ হৈছিল।
Good. Then come to page number 52.
52,
Evidence
my
in
lord.
affidavit of DW2.
My lord. Paragraph, my lord.
10.
Paragraph 10. মোৰ পিতৃ ঢুকাইছিল 17/3/2001 চনত চৰকাৰী চাকৰি আগৰতলা ইণ্ডাষ্ট্ৰিয়েল অফিচ ইন্দ্ৰনগৰ আগৰতলা কৰি থকা অৱস্থাতে ঢুকাইছিল, এই কথা সত্য।
This is an evidence in affidavit of the DW2.
DW.
Now please come to page number 20.
Page number 20, my lord.
Pension payment order, right? PPO.
My lord.
In the name of
Haridhan Roy.
pensioner is Haridhan Roy.
My lord.
When did he retire? On the left hand side, 1st of December 1986.
86, my lord.
And his estimated date of birth was 24th of February 26.
26.
Then how come he retired from service on 1st of December 1986? Both the Prosody as well as Prosody's brother placed before the tribunal that he expired while in service. And this particular PPO was exhibited by the Prosody. You have just read the Prosody in her evidence as well as in her evidence in affidavit have clearly stated that her father expired in service in the year 2001. Her projected brother also stated so, expired in service in the year 2001. And the Prosody has exhibited this PPO where it shows that this particular Haridhan Roy projected father of the petitioner, retired from service on superannuation on 1st of December 1986.
My lord. But my lord, death certificate is given by
No,
the
no,
annexer P1,
That's how itself.
my lord.
Mr. Day, you are an expert in civil cases, so
My
you know you have been handling with all the bank matters and other matters.
My
When these kind of certificates are
my
placed,
lord.
you know very well whether to trust the petitioner or not. Everything goes.
It was also exhibited before the tribunal, my lord.
You have also annexed.
Yes, my lord.
So
And
you have not
as
added
because my lord,
You have not added
originally,
anything. But thing is, this is before you.
my lord.
This is a PPO. Otherwise, it would have been a family pension. It's not a family pension. It's a pension.
And
Had he expired during his service period, it would have been a family pension to his wife.
yes,
You say
definitely,
that
my lord.
family pension was not received by your mother,
Mm, my lord.
received by the second wife at Agartala.
Otherwise, my lord, under the Immigrants Act, expulsion from
How
Assam,
can
my
it
lord,
be?
that,
Where is the proof that she is the daughter of Haridhan Roy?
my lord, the only evidence, my lord, his brother evidence is there, my
That cannot be accepted. There is no name of the petitioner along with her brother in the voter list.
My lord, the
Look at
relationships,
the
my lord, under
relationship
section
that
50 of the
school
Evidence Act,
certificate
my
issued. First of all, the school certificate have an SNLM, number one. Number two, the school certificate. Forget that part of good character or
my
bad
lord,
character.
my lord, my lord.
But really evidence of the concerned headmaster of the school.
Headmaster of the school, my lord,
This
has
said it doesn't
appeared,
know
but
anything. This was not from the record.
not for the record is burned up in 1972,
There is no statement.
my lord.
The proceeding has in her evidence written statement say that she has exhibited or she has annexed the school certificate.
Right.
Where from the school certificate was given? If it was given by the previous headmaster, because the school certificate is not that old.
No, it is issued in 89, my lord.
So then
The only evidence, my lord, his brother evidence is
where is
there.
the document to show that he is the brother?
Only the statements, my lord. Petitioner written statement as well as evidence and the DW's evidence.
Even the brother is also saying the same thing. The father expired in service.
Otherwise, my lord, it is a fact that, my lord, they have come from East Pakistan
True.
due
We
to
are not denying
religious,
that.
fear of
Right,
religious
right. Mr.
persecution,
Dey,
my
we are
lord.
not denying that. There are many people.
My lord.
But you know, those who have come from that part,
My
they
lord.
have the valid document. There are two particular communities
My lord.
who have come from the part of the country, right? At that point of time, after partition. You go to Golaghat, you go to Dibrugarh. Many will not say about that they have come from that part because they are disturbed by police. It's a fact.
My lord, it is also a fact that his father was an employee under the government of Tripura. But my lord, the
But as a
statements is
projected
here and
father,
there, my lord, it
It's
is
a
not civil
projected
error.
father.
But
It's a projected father. If he was settled at Agartala, why should he have come to Makhongao?
Makhongao, they were,
What was the requirement for? Because his grandfather was settled at Agartala.
my lord,
Petitioner's projected father settled at Agartala.
my lord, he has
Where is Agartala and where is Makhongao at Nagaon?
Makhongao, they were residing, Sambal, my lord,
When?
our petitioner's father.
What
But
made
subsequently, my lord,
What made his father or her father to come down from Agartala to Makhongao when he was established at Agartala?
my lord, they are coming in Assam. It is a fact, my lord. But since, my lord, he has married another wife, my lord,
Statement of
so
the-
his wife
statement
was
of the
allowed to
proceeding.
reside at Makhongao.
Statement of the proceeding and her projected father is that her grandfather also entered India and settled at Agartala. The statement of the proceeding as well as her brother is that her father came to Agartala, had service at Agartala. Where is Agartala and where is Makhongaon?
My lord, his petitioner's
And
mother,
look at the thing that
along with his brother, was
as per
residing.
the
was this-
PPO, you will see since when he is in service.
The relationship, my lord, evidence that, my lord, the relationship that can be considered, my lord.
On what basis?
My lord,
You tell us, you're
Under-
dealing with all the bank cases. We have
under
to consider only the
under
Evidence
section
Act.
50, my lord, evidence act, my lord, that can be, my lord. Relationship establishment of, that is a 2021 4 GLT, my lord, there is a judgment, my lord,
2020.
2021.
Hmm.
The volume 4 GLT 664 page. Shujabali versus Union of India.
664.
664, my lord. Paragraph 15.
Twenty-one.
2021 4 GLT, my lord.
You go to the মাটি দিবা আজি মাটি ঠিক করে লব কালি আইছিলি মোক পড়াটো 4 দিন 6 এনেকে থাকো Which parameter day?
Paragraph 15, my lord.
দুপুরে মাটি দিব
Immediately.
Now, this in a matter of Foreigners Act, while considering the or rendering the opinion, is not it the duty of the proceeding as per the law laid down by the apex court? It is the duty on the part of the proceeding to place everything before the tribunal and to proved the linkage. And if the linkage that is proved is not proved in accordance with law, if such opinion, there is a case, certain materials will not, which you have placed before us. It's a case where some of the documents were not considered by the tribunal. And that's where the court considered the decision of the apex court and section 50 of the evidence.
Right.
But here the proceeding has relied upon certain documents
Right.
to establish her linkage
Right.
with her projected father. Now, there is no voter list of projected father and projected mother together. The proceedings projected brother has said the name of her mother, his mother, was never in the voter list. Right? Now, the only thing is that only at one point of time, at Makongaon, in the year 1970,
My
there
lord,
was
since,
a Haridhan Rai.
since, my lord, his birth, he is in Makongao, petitioner, since his birth, my lord.
Petitioner is there. We're not
Petitioner
denying
is-
about the petitioner. What about her projected father?
But the father, my lord, used to come from Agartala,
That's fine.
Makongao, Agartala, in this way, my lord,
We understood.
my lord.
But thing is this, the certificate, the school certificate to show the linkage, not been proved to but the Gaon Panchayat certificate, not been proved to but.
Gaon Panchayat certificate, my lord, secretary in charge also appeared
And
and
look at her
given
statement.
evidence. And she stated that record is not maintained by them, my lord. So
Without
if
the
the
record-
record is not maintained by them, my lord, that
Then
is another
whatever
issue,
it-
but
what basis the
certificate
be
is given,
accepted
my lord.
in evidence. There
Sin-
has to be a record.
They knows on the basis of
See,
70 voter list, my lord, and the others, my
that
lord,
can
it
be
is issued.
possible. How do you reflect a petitioner is the daughter of Haridhan Rai? Where from? The school certificate not from. The Gaon Panchayat secretary certificate is not from. Moreover, the DW4 who appeared on behalf of the Gaon Panchayat clearly stated it was issued only purpose of NRC and not for ill. Furthermore, no record is maintained.
Linkage, my lord, linkage,
That is clearly
to
mentioned.
establish the
So,
relationship.
the headmaster of the school, the Gaon Panchayat secretary. Clearly laid down on the basis of that, that they do think this is a fit case. And above that, the fact stated by the proceedee as well as her projected brother, that father expired in 2021 while in service, also wrong. Because he already he was superannuated in 1986.
Superannuation is, he was a
Not
retired,
expired in
retired.
service. So doesn't know. First of all,
Superannuation.
the petitioner doesn't know.
My lord,
where his
petitioner
father
says
was.
that while in service, but they, perhaps, my lord, they have mistaken, doing mistake
Not
while in
this is
service.
Counsel appearing for the petitioner. And Mr. D. Sharma, standing counsel, Home Department, Assam, for the restaurant number 2 and 3. Also heard Mr. P. Sharma, additional senior government at Assam, for the restaurant number 4, as well as Mr. H. Cooley, standing counsel, Election Commission of India, for the restaurant number 5. On being referred by the Superintendent of Police Border Nagaon. After hearing the petitioner and other parties and considering the evidence adduced by her, learned member Fairness Tribunal, Second Nagaon, in FP case number 3477 of 2011, within bracket SP reference case number 1872 of 1998. By the impugn opinion of order dated 12/7/2022, appoint the petitioner to be a foreigner under the Foreigners Act 1946. Or post 1971 state. Dissatisfied, the said opinion dated 12/07/2022 noted above. The petitioner has filed a state petition on 03/01/2020. Before proceeding further, we like to peruse the relevant records of FT case number 3477 of 2011, wherein the learned member Fairness Tribunal, Second Nagaon, for the impugn opinion of the order dated 07. All for the record. in the entity. Direct. That person to the impugned opinion with it. 1207. The peer review. So when the place on or before 20, but right. Let's record it for motion immediately on this. Have you saw copies on the other side?
Lordship, yes.
For court's convenience, we have extra copies also. We have extra copies also for Lordship's perusal. In this case, we have filed a review application on behalf of the state because at the time of implementing the order, when it was deliberated, Lordship. Lordship.
Statement was out.
My lord, name. Lordship. So this review application is preferred against the order of the appeal of 1/6/2023.
You have seen that order.
That's Lordship. Now, after that, while at the time of implementation, it went to the highest authority and this was the note. It was a part of the record. Last time I produced it,
Note of the
Chief Minister.
Chief Minister. I think so the respondents have annexed it in the affidavit.
Yes.
Yes.
So thereafter, the CM, the Chief Minister wanted that who is at fault, whether the SP or the.
That's a part of the affidavit of the.
Yes,
respondent.
Lordship. Yes, Lordship. Now, to find out who is at fault, then inquiry was done by the CID. And it was found that the person who actually was the vigilance officer, Mr. Rupam Datta, Dibbajyoti Datta, he did a perfunctory inquiry. He did not got into the depth of the matter. Why? That I would like to place. Now, subsequently, the inquiry was completed, and on 26th of December, the final inquiry report has been submitted to us. This is a part of our additional affidavit, which I'll take to your Lordship little later. Now, if Lordship is pleased to look at the judgment of the learned single judge at page 18 of the review, 24/11/2022.
Is 80, right?
18. This is a judgment. Here the relevant portion will be
Page 22.
page 21. At this stage, D. Mujumdar, learned additional AG, has produced a record before this court, which contains the inquiry report submitted by the SP CID with regard to so and so. And here, page 22, may I read this paragraph? In respect of Monsoon Borkakoti,
The state level scrutiny committee, after making necessary inquiry, has considered that the petitioner is not belong to.
eligible,
right?
eligible.
He belongs to general category. He doesn't belong to that particular.
Exactly, Lordship.
That was challenged.
That was challenged.
In that proceeding, record was placed.
Record was
where the-
placed.
One of the inspector report was placed. And the
This report,
inspector
the opinion,
Inspector report clearly shows that the petitioner belongs to the coach community as she adopted her mother's place.
And the enquiry, this enquiry officer's report is contradictory to the DC's office. That is the case.
No, that's what.
Yes.
That's what. Then ultimately the honorable single judge passed that order.
On the basis of the vigilance
Based on the
officer's opinion.
CID
Yes.
report, right? And it was challenged and then accordingly that it was set aside.
Yes, now.
The state level scrutiny committee's decision that the petitioner was.
Lordship.
That was set aside. And then it was in particular complainant approached the writ appeal and the writ appeal was dismissed.
Lordship, right? And it was not filed by the state. State was about to file. In the meantime, the third party preferred it. Third party preferred it earlier, and the state government took the decision to file the appeal on 14th of June. When the 14th of June, the state government was not in the knowledge that the appeal was pending, although some advocate appeared. On 1st of June itself, at least 14 days ago, 2 weeks earlier, the writ appeal was dismissed. Basically, here also, if Lordship is pleased to look 1 or 2 lines of the writ appeal order. The appeal starts at page 27, paragraph 4. Paragraph 4, last line, page 30. This is a submission of my learned senior friend. However, based on the fact that the girl child was residing with her mother and was following the customs and rituals of the Koch community, a certificate dated 13/11/2006 was issued in favor of the respondent writ petitioner, affirming that she belongs to Koch community OBC. So this point to be noted here, that their submission is the girl child was residing with her mother. This is where
also the finding of the inspector.
exactly, Lordship. That is where we have a totally different picture in the final opinion now. And on the basis of this, the division bench.
Uphold the order of the learned single.
Yes, here also the division bench also paragraph 14. Paragraph 14, in the wake of the discussion made herein above and keeping with the categorical affidavit filed by the state government authorities before the learned single judge, placing on the report dated 3/10/2019, which was prepared after thorough inquiry conducted by the vigilance officer, that is Inspector of Police, Rupamjyoti Datta, in that present case under the supervision of the SPCID, concluding that the allegations regarding falsity of the social status certificate of Srimati Monsoon Borkakati was based on no truth. And the only course of action required to be taken as per the ratio of the judgment in the courts of Kumari Madhuri Patil was to accept the said report of the vigilance officer. For the sake of repetition, it may be mentioned that the state level scrutiny committee, while passing the impugned speaking order dated so-and-so, did not objectively consider the inquiry report of the vigilance officer, that is Inspector of Police, which was mandatory requirement as per the guidelines laid down by the Supreme Court. A perusal of the speaking order would reveal that the scrutiny committee, though referred to the report submitted by the SPCID, but thereafter no discussion whatsoever was made to the findings of the inspector's report in the speaking order. On the contrary, while coming to the conclusion of the respondent writ petitioner was not entitled to the benefit of OBC certificate, scrutiny committee relied upon a parallel report which got concluded to Circle Officer Jorhat Revenue Circle. Apparently, in terms of judgment of Kumari Patil, the Circle Officer has no jurisdiction. I am coming to the next paragraph. Testing the report of the vigilance officer, that is Inspector CID, on the touchstone of the principles laid down in Kumari Madhuri Patil's case, we find that the inquiry report submitted by the inspector CID does not indicate, even in the slightest, that the particulars given by the candidates were false or that the social status certificate had been fraudulently obtained. So the Honorable Court held that there is no doubt, not even a slightest doubt about the report given by the inspector of CID. And on that basis, next paragraph, Lordship. As the report of the Inspector CID, which was submitted after concluding a thorough inquiry in terms of Kumari Madhuri Patil, did not give any indication that the social status certificate was obtained by the respondent by providing any false or fraudulent information, rather concluded that the social status certificate was validly and lawfully obtained The authorities has no option but to accept the report and affirm the social status certificate of the respondent writ petitioner as per the guidelines contained in paragraph 13.7 of the judgment. Hence, contrary to the conclusion drawn by the state level committee, is absolutely illegal and warranted, and therefore upheld the learned single judge. The story starts now. When thereafter they came to the learned single judge for her restoration in service, and while the government took the decision to restore it, but before that, we have to find out why that enquiry report is, whether it is a valid enquiry report, it was genuinely done or not, and enquiry was directed. In the enquiry report, in the enquiry to find out whether the earlier enquiry was correctly done or not, whether there is any malafide intention on the part of the CID officials, this note was put on, Lordship. This note, and thereafter on 7/8/2023, page 50.
Page 50 where?
Page 50, with reference to the subject cited above, this is of 7th of August 2023. I would like to inform you that an enquiry was conducted into the matter. The enquiry was conducted by Sri Punamjit Nath, APS Deputy Superintendent of Police. The enquiry revealed that the Inspector Divyajyoti Datta, the then inspector, had made a perfunctory enquiry. But we have to substantiate it now. Just saying this will not be sufficient. Let us go to the first report, page 51. From paragraph 5 onwards, page 51. Inspector Divyajyoti Datta had submitted his enquiry report to the Superintendent of Police CID on 3/10/2019 in response to the above mentioned letter received from the Director of Welfare of Plain Tribes and Backward Classes. The detailed report in connection with the matter has already been submitted on 17 July. The following observations are being made. In the OBC certificate issued to Sri Monsoon Borkakoti by All Assam Backward Classes Association dated 13/11/2006 and countersigned by the then EAC, Jorhat, the name has been mentioned as Monsoon Borkakoti. There is a mistake on the spelling. Sri Diganta Borua, village headman of Sekonidhara Gaon, Jorhat East Revenue Circle, under whose jurisdiction Srimati Monsoon Borkakoti currently resides, had provided a copy of the letter he received from Sri Surendra Nath Bora, the then village headman of Doirongia, Gwalgaon, informing that late Siva Prasad Borkakoti, father of Santanu Borkakoti, along with his family, was residing in so-and-so Gaon, Moja Misamari, Golaghat, before 1950, and they belong to Kush community. So one document which they have furnished, that father was a Kush community person. Sri Surendra Nath Bora, the then village headman of so-and-so Gaon, denied issuing such letter confirming that they belong to Kush community, thereby contradicting the statement of Sri Diganta Borua, village headman of Sekonidhara Gaon, Jorhat East Revenue. Srimati Monsoon Borkakoti had received a letter dated 26 March 2019 from the Deputy Commissioner Jorhat asking her to bring the original documents for verification. Later, the aforesaid letter was found to be fake, for which R.A. Korati, IAS, the then DC Jorhat, had submitted a written complaint dated 3rd April 2019 to Officer in charge Jorhat PS against unknown persons for faking her signature and official seal. On receiving the complaint, a case was registered under so-and-so. Following points were not incorporated in the earlier Enquiry Officer Inspector Divyajyoti Datta's report submitted to SP CID dated 3/10/2019. The above mentioned observations may be taken into account if deemed fit in ascertaining the malafide intent on the part of the previous EO. Thereafter, Lordship, the state had decided to start a fresh enquiry through, if Lordship is pleased to take the additional affidavit today. This additional affidavit we have filed yesterday. Paragraph 3, page 123. This is the new twist to the whole story, Lordship. The deponent respectfully states that pursuant to the direction issued by the competent authority, the SP CID Ulubari Bhaid, his letter dated 26 December 2023, has submitted a detailed enquiry report on the status of caste certificate in respect of Srimati Monsoon Borkakoti, ALRS, under suspension, as submitted by the enquiry officer Srimati Moromi Das, APS, Deputy Superintendent of CID, Assam. The aforesaid enquiry report submitted by the CID clearly indicates that Srimati Monsoon Borkakoti is not entitled for the OBC certificate, as her father belongs to the general category and she received all kind of supporting from her father. The story earlier was that she was staying with her mother alone and she has adopted coach culture and customs. Here, what exactly has been found, Lordship will be pleased to come to the enquiry report now. Page 127. Submission of the enquiry in connection with caste certificate of so-and-so. After a detailed enquiry, verification and examination of documents, records pertaining to the matter in Jorhat, Golaghat and Guwahati, I would like to submit the following. Srimati Monsoon Borkakoti, daughter of Santanu Borkakoti and Srimati Purnima Datta, was born at Sekonidhara Gaon. Is currently residing in Sekonidhara Gaon, Moja number 3, Jorhat Revenue Circle, Jorhat, along with her parents and younger brother Mrinmoy Borkakoti. Her father, Dr. Santanu Borkakoti, is a retired medical officer appointed to Class 1 cadre of Health and Family Welfare Department, Government of Assam, and is residing at the same place with his wife and children. Her mother, Srimati Purnima Datta, who is also a government employee, is currently working in the Irrigation Department of Government of Assam as senior assistant. Dr. Santanu Borkakoti was born and brought up in Guwahati, Chandrabala Borwa Lane, near SBI Evening Branch, house number so-and-so, Skilpukuri, Sanmari, Guwahati. His ancestral roots belongs to Betioni Kakoti Gaon, Hekial, Golaghat. Sri Torun Chandra Hazarika, the village headman of Betioni Kakoti Gaon, confirmed that the great-grandfather of Dr. Santanu Borkakoti was late Jagannath Kakoti, who shifted his residence to Guwahati. His son was late Sivak Prasad Kakoti and his son is Dr. Santanu Borkakoti. Srimati Monsoon Borkakoti is the daughter of Santanu Borkakoti and they belong to Kolita community, which is a general category. Number 4. Srimati Purnima Datta was born to late Ramchandra Datta and mother Srimati Nirupama Datta and brought up in Sekonidhara Gaon, number 3, Town Moja, Jorhat East, in the Club Road, which is located in the heart of the city, Club Road in Jorhat. She has one sibling, namely Puspa Datta, who resides in Bikhoynagar, Jorhat, with her husband. The village headman, Sri Digonta Borwa of Sekonidhara Gaon, stated that they belong to Koch community. The maternal home of Srimati Monsoon Borkakoti, daughter of Purnima Datta, was reconstructed 10 years back. The land dates back to her great-grandfather, late Rajan Datta and late Kusumi Datta, who also had 2 daughters. Srimati Monsoon Borkakoti completed her school from Don Bosco High School, Lichubari. Lordship will note this, Don Bosco School, missionary school, in the year 2007, Jorhat, and passed out with 72% and secured letter marks in 3 subjects. She completed her higher secondary from Luit Valley Academy, Jorhat in 2009 with state highest marks in political science. She completed graduation from Cotton College in political science in year 2012, where she secured first class second position with distinction and completed her master's in political science from Cotton College with first class in the year 2015. It is pertinent to mention that during her higher studies, she was residing at her father's ancestral house at Silpukuri from 2009 to 2015. 6 years she was in Guwahati. An OBC certificate dated 13/11/2006 was issued in the name of Monsoon Borkakoti, daughter of so-and-so of the Assam OBC, which was purportedly countersigned by ESC, Jorhat, showing Monsoon Borkakoti belonged to Koch community. This certificate was used by Srimati Monsoon Borkakoti for claiming benefits of OBC in her APSC examination. It can be clearly seen that in the name of the certificate is differently spelled. Srimati Monsoon Borkakoti herself admits that her mother belongs to Koch community, whereas her father belongs to general category. She also submits this. During the course of inquiry, visited the office of All Assam Other Backward Classes Association in Jorhat District, Congress Bhavan, to verify the documents submitted by Monsoon Borkakoti at the time of applying for her OBC certificate. It is to mention here that the OBC certificate of Srimati Monsoon Borkakoti was issued on 13/11/2006, but the records available in the office are only from after 2007. the office bearers of the All Assam Other Backwards Classes Association Jorhat informed that they have not kept any record up to year 2007 and showed one preceding dated 9/9/2007 relating to destruction of records, documents, etc. During the course of inquiry, visited the office of DC Jorhat to verify the documents submitted by Monsoon Borkakoti at the time of applying OBC certificate. They stated that no such records were maintained by the office as documents were issued by the All Assam OBC Association. During inquiry, it is found that Monsoon Borkakoti had received letter dated 26/3/2013 19 purportedly from DC Jorhat asking her to bring the original records for verification. Later, the aforesaid letter was found to be fake, for which R.A. Korati IAS, the then DC Jorhat, had submitted a written complaint dated 3/4/2019 to the OC Jorhat PS against unknown persons for forgery of her signature and official seal. The case was investigated and suspected documents were sent to FSL for examination. After completion of the investigation, the IO returned the case in final report by dated 31/2020 as true, but no clue was involved accused persons and sent the case diary along with relevant documents to the honorable court. So the document was found to be a fake one. It is found to be correct, but who was at fault, that could not be ascertained. During the inquiry, it has come to light that this is now important aspect, Lordship. During the inquiry, it has come to light that Dr. Santanu Borkakoti applied for OBC certificate in the month of February 2019. The daughter says he is a general and he himself applied for OBC course certificate. Sri Digonto Borua, the village headman of the Sekonidhara Gaon, forwarded the application stating that Dr. Santanu Borkakoti belongs to coast community. All the supporting documents are part of the record here. Sri Digonto Borua stated that he forwarded on the basis of a certificate purportedly issued by the then village headman of Doirongia, Gwalgaon, Dergaon, Golaghat, Sri Surendranath Bora. The application was rejected as per the statement from Kamal Gogoi, President Jorhat District Other Backward Classes Association, after a complaint received from Anti-Corruption Liberation Union, Jorhat. During the inquiry, Sri Surendranath Bora, the then village headman of Doirongia, Gwalgaon, Dergaon, Golaghat, was examined. He stated that the letter paid and the signature was his, but the content of the letter was not written by him, and he also stated that in writing. During the inquiry, a letter was submitted by the Anti-Corruption Liberation Union, Jorhat. The letter was addressed to the Circle Officer, Dergaon Circle, dated 29/1/2021. From the then village headman of Doirongia, Gwalgaon, Dergaon, Golaghat, Sri Surendranath Bora. The letter stated that Dr. Santanu Borkakoti rented a house in the same village for 3-4 years, and the landlord belonged to the Koch community. It may be assumed that on the basis of being a tenant in Dergaon, and also on the strength of the OBC certificate of his daughter, Monsoon Borkakoti, Dr. Santanu Borkakoti applied for an OBC certificate. In another document regarding furnishing of RTI reply from Additional Deputy Commissioner Golaghat addressed to Anti-Corruption Liberation Union Jorhat was submitted. It stated that Dr. Santanu Borkakoti did not have any ancestral property in Doirongia, Gwalgaon, Dergaon, Golaghat. During the inquiry, a fake OBC certificate issued in the name of Dr. Santanu Borkakoti bearing caste certificate number so-and-so dated 19/3/2019 was collected from Anti-Corruption Liberation Union, Jorhat. It assumed that the original copy must be in the possession of the beneficiary, Dr. Santanu Borkakoti. However, when we requested for meeting him to question about the certificate, his daughter, Srimati Monsoon Borkakoti, restrained us on the pretext of her father's ill health. Moreover, a formal communication by dated 14/12/2023 was issued to Monsoon Borkakoti. Till date, there is no response in respect of the said purportedly fake certificate. Srimati Purnima Dotto was issued the OBC certificate dated so-and-so on number so-and-so on 6/9/2019. An RTI was filed by the representative of Anti-Corruption Liberation Union, Jorhat, praying for the official record of Monsoon Borkakoti's brother, Sri Mrinmoy Borkakoti, for admission in BSc Bahana College, Jorhat. The reply of the PIO, Bahana College, Jorhat stated that the caste of Mrinmoy Borkakoti, son of Dr. Santanu Borkakoti, is recorded as general category. After going through all the documents recorded and examining the persons concerned, I have come to the conclusion that Srimati Monsoon Borkakoti's mother belongs to Coast community, which is a recognized OBC. Srimati Monsoon Borkakoti's father belongs to Kolita community, which is a general category. Srimati Monsoon Borkakoti used the OBC certificate issued on 13/11/2006 in the name of Monsoon Borkakoti, daughter of Santanu Borkakoti. Srimati Monsoon Borkakoti resided in her maternal home in Jorhat, and by her admission, her parents are living together and have happily married life. During the inquiry, it was well established that Monsoon Borkakoti's parents were never separated nor divorced. Her father took care of her all along. She did not suffer any disabilities socially, economically, and educationally. In fact, the house they are residing was rebuilt 10 years back, which reveals that the house was constructed after marriage of her parents, and her father was actively involved in the construction of the house. She stayed at her father's ancestral residence in Silpukhuri, Guwahati for her higher studies from 2009 to 2015, which also proves that her father have not abandoned her nor or neglected her at any point of time. It is also pertinent to mention that both parents were class 1 and class 2 government servants, and they fall into the creamy layer as per government OM dated 13/9/2013. It is pertinent to mention that Dr. Santanu Borkakoti have tried to manipulate the inquiry by applying for OBC certificate in the year 2019, for which he was not eligible, and also procuring one fake OBC documents from Golaghat district in the year 2019. In my opinion, Dr. Santanu Borkakoti tried dubious methods to procure OBC certificate in 2019, and appropriate criminal prosecution may be initiated in this regard. According to the government OM dated 13/10/2019, published by the Ministry of Social Justice and Empowerment, dated 21/5/1977 from Ministry of Home Affairs, it is stated, it is established that the child has been brought up in the surroundings of a notified community to which the mother belongs to, and also suffered the deprivation, indignities, humilities, and handicap like any other member of that community. And he or she was always treated to be a member of the mother's community, not only by that community, but by the people outside the community as well. Then such child of separated, divorced, single woman has to be treated as member of the scheduled caste community and would be entitled to receive benefit as such. Therefore, Srimati Monsoon Borkakoti is not entitled to claim the benefits of OBC, as her father belongs to the general category and her parents were never separated, divorced, and she received all kind of supports from her father. This is the latest report, and thereafter, Lordship will kindly see the relevant documents. I'll place. He has a brilliant career, Lordship, but the father has messed up everything. Page 156 is the complaint of the Deputy Commissioner of the Police. Very detailed inquiry this time it has been done regarding that fake document of the Deputy Commissioner. This is the FIR. Here, next page 157, the report, the FR action taken report, 15/12/2023. The SP wrote to this inquiry officer, Ma'am Oromi Das, last few lines. During the course of investigation, IO examined the complainant and recorded her statement under section 161 and examined other witnesses and recorded their statement under 161. The IO sees some relevant documents as per seizure list, send the exhibits to FSL Guwahati for examination and expert opinion, as well as collected the report. On the report, the expert opined that the person who wrote the blue and close writings and signature stamped and marked SI1 and S9 did not write the red and close writings similarly stamped and marked Q1. And it has not been possible to express any definite opinion regarding the authorship of rest of the question items on the basis. After completion of the investigation, the IO returned the case in FR by Jorhat so-and-so as true, but no clue of involved accused person, and sent the case diary along with relevant to the Honorable Court. So the persons who are involved, they could not be identified. Now page 158, the father's application. This was applied in 2019. Name of the applicant, Santanu Borkakoti, father's names late Sibo Borkakoti, etc., etc. Address, permanent address, Green Golf Road, Club Road. That's a posh area in Jorhat. Sekonidhora village, etc., Lichubari police station, mobile number, caste, coach. I do hereby declare that the information furnished above are correct and true. I will be responsible by law if I do false. Signature is this Borkakotis. Next page, the comment of the district president, other serial number 9, recommended. And serial number 6 at previous page, village head ward commissioner comments, আবেদনকারী কোচ সম্প্ৰদায়ৰ লোক হয় বুলি এখেতৰ পিতৃগৃহৰ গাঁওবুঢ়াৰ প্ৰতিবেদন পোৱা যায়। So daughter is saying father is general and father is saying on the basis of daughter's caste certificate that he is a coach. So he got procured a certificate from Golaghat, and the Golaghat Gaonbura also later on said that it is not mine. Then page 161. Sorgyo Sabhapati Jorhat Onyo Pispora. Bihito এই যে ক্লাব ৰোডৰ নিবাসী মনসুন বৰকাকতিৰ পিতৃ শান্তনু বৰকাকতি এগৰাকী কোচ সম্প্ৰদায়ৰ লোক হয় বুলি জানিব পৰা গৈছে। যিহেতু শ্ৰী মনসুনৰ পিতৃ কোচ সম্প্ৰদায়ৰ লোক হয় বুলি গৃহৰ পিতৃগৃহৰ গাঁওবুঢ়াই শ্ৰী সুৰেন্দ্ৰনাথ বৰাদেৱে প্ৰমাণ পত্ৰ দিয়ে। সেয়ে মনসুন বৰকাকতি এগৰাকী কোচ সম্প্ৰদায়ৰ লোক হয়। So OBC authority says as because the father is a OBC and coach, therefore she is also entitled to be a coach community person. Then next is another that kind of certificate. Then page 165, the Gaonbura certificate Doirongia Gwalgaon, সাক্ষীৰ উপস্থিত জ্ঞাত তথ্যৰ ভিত্তি দিয়াৰ দ্বাৰা প্ৰমাণ দিয়া হ'ল যে শ্ৰী শান্তনু বৰকাকতি পিতা সোয়েনছ বৰ্তমান যোৰহাটৰ নিবাসী, তেওঁ পিতৃ শিৱপ্ৰসাদ বৰকাকতি মোৰ মিছামৰা মৌজা গোলাঘাটৰ প্ৰকৃত নিবাসী, আৰু তেওঁলোক অসমীয়া জাতিৰ উপজাতি কোচ সম্প্ৰদায়ৰ লোক আছিল। তেওঁলোকৰ পৰিয়াল প্ৰায় 1950 চনৰ আগতে গোৱালগাঁও অঞ্চলৰ পৰা উঠি যোৱা আমাৰ জ্ঞাত। These are all manipulated documents. Then he also claimed on the basis that he is residing in Dergaon. So page 168, with references subject, I am enclosing here with the documents submitted by the circle officer of Dergaon Revenue Circle, Golaghat. Next page, the report of the circle officer of Dergaon Rajya Sakra, Dergaon Revenue Circle. উপৰোক্ত বিষয় প্ৰসংগ সন্দৰ্ভত আপোনাৰ তথ্য জনাৰ অধিকাৰ আইনত তদন্ত অধীনত কৰা আবেদনত তথ্য উল্লেখ কৰা হ'ল। দেৰগাঁও ৰাজ্য চক্ৰ মিছামাৰা মৌজাৰ দয়াল গোৱালগাঁৱৰ শ্ৰী ডক্টৰ শান্তনু বৰকাকতি পিতা সোয়েনছ নামত বা তেওঁৰ পূৰ্বপুৰুষৰ নামত কোনো মাটি বাৰী বা আন সা সম্পত্তি দয়াল গোৱালগাঁৱত নাই। তেখেতৰ পূৰ্বপুৰুষৰ কোনো তথ্য পোৱা নগ'ল। ডক্টৰ শান্তনু বৰকে জাতি প্ৰমাণ সন্দৰ্ভত দৈৰঙ্গীয়া গোৱালগাঁও গাঁওবুঢ়া সুৰেন্দ্ৰনাথ বৰাই দাখিল কৰা ডক্টৰ শান্তনু বৰকাকতিৰ কন্যা শ্ৰী মনসুন বৰকাকতিয়ে এখন জাতিৰ প্ৰমাণ পত্ৰ কোচ সম্প্ৰদায়ৰ ইয়াৰ লগত দাখিল কৰা হ'ল। দৈৰঙ্গীয়া গোৱালগাঁৱৰ গাঁওবুঢ়া সুৰেন্দ্ৰনাথ বৰ্তমান বয়স 70। Then on 14th 12 page 171, Moromi Das wrote a letter to Monsoon Borkakoti. The undersigned has the entrusted to inquire about your caste verification certificate as directed by Joint Secretary to the Government of Assam Home A Department, Dispur. Therefore, you are requested to provide supporting documents such as your academic qualification certificate, High Court's order, parents' caste certificate, and any other documents relevant to the inquiry, hoping you will cooperate with us till the completion of the inquiry. Then, page 172, this is from the President of All Assam OBC Association, Golaghat District, to a RTI application. These documents were submitted to Dipankar Hemrong, Secretary, Golaghat District OBC Students Union. Next page, Lordship will kindly see. President address to this gentleman, the father, Borkakoti, signature of the applicant. Kindly issue a caste certificate in favor of the undersigned for educational, business, central service, state service. The necessary particulars are given below along with 2 copies of passport size photographs, supporting documents such as admit card of school, etc. Names, Santanu Borkakoti, father's name so-and-so, mother's name so-and-so, address. Now here he has written Dergaon. Caste OBC, subcaste Konch. Next page, he obtained this certificate and the certificate original copy is with the father. When the daughter was requested to allow the inquiry officer to meet Santanu Borkakoti, it was refused on the ground that he is not keeping well. The counterfoil of the All Assam Other Backward Classes Association, Santanu Borkakoti so-and-so, caste certificate, caste is Koch Rajbongsi, here 1 step ahead. Koch Rajbongsi is different, Lordship. So when we do certain things wrongly, Lordship, we always keep traces. Here in the counterfoil, there is no signature. Father's OBC certificate obtained from Golaghat OBC office. The main certificate has the signature. Then another certificate. Next page 175. He belongs to Upajati Kus Sampradaya. 3rd line from the bottom. Bikhe Dr. Santanu photo Sinaktokaran Kori dia hol. So all these manipulations are being done. And all these certificates were displayed in various TV channels also. These copies were also annexed at page 176. Mother was working regularly from 2005 and she obtained a certificate of OBC in 2019, page 177. Purnima Datta. But there is no doubt about this, the genuineness of this. Regarding the brother, page 178, the PIO, Public Information Officer of Bahana College said, in response to your letter dated above, I have the honor to submit that the information of Sri Mrinmoy Borkakoti as per our official record against his application for admission in BSc in the year 2018. His caste is general, but there is no record of community. Now, the learned single judge as well as the division bench heavily relied on the statement that father belongs to general caste and mother belongs to Koch. And this particular lady, the writ petitioner, was staying with her mother only. From all these materials, it is abundantly clear that she was happily living with her parents, not with a single parent, whether it is father or it is mother. The father settled in Jorhat, in Club Road in Jorhat, heart of the city. Page 179, we are not on criminal layer issue here, but criminal layer issue will now definitely crop up. So the father is a class 1 officer of the state government being a doctor, mother is a class 2 officer in the irrigation department. Either way, she is not entitled, even if she is OBC. Then also now things have come up to light. Now the government cannot close his eyes to the criminal layer issue now. Criminal layer, non-criminal layer. Who is entitled? The non-criminal layer belonging to OBC are entitled for all these benefits. That happened, Lordship will kindly know that in the medical college admissions, we have faced this problem. Now, what is the issue? What is the present law on this? Page 180, 181. They are trying to project the case all along that she is staying with her single mother in Jorhat, in a Koch community, a dominated area. So in that situation, in whose case a caste certificate can be given on the basis of the status of the mother, that law has been laid down in this notification issued by the Ministry of Social Justice and Empowerment, Department of Social Justice and Environment, Government of India, page 181. to all the chief secretaries of all state governments and union territory administrations. Subject caste status of offspring of separated, divorced and single women. I am directed to say that comprehensive legal position about the status of the offspring born to couples where one or both of the spouses is or are members of scheduled caste or scheduled tribe was circulated by Ministry of Home Affairs dated 21/5/1977. It has been represented to this department that the said guidelines were silent regarding caste status of offsprings of separated, divorced single women, that is whether caste certificate can be issued to the children of separated, divorced or single women on the basis of caste of their mother. This is the question now, because their whole projection is that on the basis of her mother's caste, she is entitled. The Supreme Court in Ramesh Bhai Naikas versus State of Gujarat's case stated, in an intercaste marriage or marriage between a tribal and non-tribal, there may be a presumption that the child has the caste of the father. This is the regular and general rule. These presumptions may be stronger in case where the intercaste marriage or the marriage between a tribal and non-tribal, the husband belongs to a forward caste. But by no means the presumption is conclusive or irrebuttable and is open to the child of such marriage to lead evidence to show that she was brought up by the mother who belonged to the scheduled caste, scheduled tribe. By virtue of being the son of a forward caste father, he did not have any advantageous start in life, but on the contrary, suffered the deprivations, indignities, humilities, and handicaps like any other member of the community to which her mother belonged. Additionally, that he was always treated a member of the community to which her mother belonged, not only by that community, but by people outside the community as well. GNCT of Delhi instructions on issued of caste certificate inter alia requires the applicants to produce a caste certificate of a relative from the paternal side. The said instructions were challenged in the Delhi High Court in the case of Rumi Chaudhary versus Department of Revenue, Government of NCT. The Honorable Court in its order dated 14/8/2019 inter alia stated, the practice of issuance of caste certificate based on the caste of father is not without exceptions. In certain cases where it is established that the children have grown up in a notified community or tribe, I have said, Jorhat Lordship will kindly mark, club area. The children have grown up in a notified community or tribe and have suffered all the disadvantages and deprivations belonging to such community. The office order could not come in the way of issuance of caste certificate that the applicants belong to caste of their mother. Here, this particular writ petitioner all along stayed in Jorhat, heart of the city, one of the post area in Jorhat, and also in Silpukhuri in Guwahati, 6 years of her educational life. Next page. In view of above observations by the Supreme Court and Delhi High Court, where it is established that a child has been brought up in the surroundings of a notified community to which the mother belongs to and has suffered deprivations, indignities, humilities, and handicap like any other member of that community, and he and she was always treated as a member of the mother's community, not only by that community, but by the people outside the community as well, then such a child of a separated, divorced, single woman has to be treated as a member of scheduled caste community and would be entitled to receive benefits as such. However, each individual case will have to be examined in the light of existing facts and circumstances in each case. It is required that these instructions may be circulated amongst all the authorities empowered to issue scheduled caste certificates. So this is the present law. Whatever was done by that particular CID inspector in 2019, in spite of knowing all these things, these were not incorporated in the report. And he tried to say that the girl is staying with her mother only, and the Honorable Court also observed, very clearly observed in the judgment or the division bench, that the girl is staying with her mother only. And look at the conduct of the family, Lordship.
Don't be. Cannot.
These are all on records.
That we have seen. But anyway.
These are on records now.
Because that particular issue is not before us.
Absolutely. But
we will not talk
during
on
the inquiry, it has been found, because to give genuineness of the certificate of the daughter, the father also tried to procure a OBC
Let
certificate.
it be among us, because
Now,
we understand.
having known all this, whether the state government should implement the order by learned single judge, or we have to come before this honorable court and placing all the complete facts. That is why we have come by filing this review application, because all these facts were not before the learned division bench at the time of hearing on 1st June 2023. Ultimately, if Monsoon Borkakoti, state government actually allowed her to join. She was serving. She is under suspension now. So when complaints started flooding, this is not only one single complaint. 3 complaints came. One from Jorhat, one from Nagaon, and another complaint received by APSC. Although in our record, the record of the Honorable Court, only one complaint has been highlighted, but there are 3 complaints. In fact, APSC first wrote to the state government that we have received this from, kindly verify the status of the OBC status of Monsoon Borkakoti. So state government has nothing vindictive against anybody, but only concern is that a genuine OBC candidate should not be deprived. We have to follow the spirit of and mandate of Article 14 and 16 in true spirit and letter. So facts are like this, Lordship, and whether on the basis of these facts, whether we are being able to convince this honorable court or not, we have no idea. But subsequent development is very clear that this particular writ petitioner is not entitled for OBC certificate. And thereafter, Lordship, what we have done, now we have not stopped here. We went one step further, page 183. So the secretary to the government of Assam from the personnel department wrote to the secretary to the social welfare department on 27 December 2023 with reference to the subject and discussions held in the office of the Honorable Chief Minister on 28 December 2023. I am directed to enclose here with a report of the press inquiry done by the CID Assam on caste certificate in respect of Srimati Monsoon Borkakoti, dated so-and-so, for taking necessary action from your end. So now the social welfare department, no, not social welfare department, the Department of Welfare of Scheduled Caste and Backward Classes Assam, Lordship will kindly come to page 184. This notice was issued on 27/12/2023 to Monsoon Borkakoti. Show cause notice we have given. We have not straightway acted to recall her certificate. So we are giving and we are following the mandate of the Madhuri Patil's case. Whereas on receipt of the communication from the Joint Secretary of Government of Assam Social Welfare and Social Justice and Empowerment Department Dispute regarding press inquiry done by CID Assam on your caste certificate, and whereas SP CID by letter dated 26/12/2023 had submitted the inquiry report on the status of your caste certificate as doubtful, which was carried out by the inquiry officer Srimati Moromi Das APS Additional SP CID. Whereas in pursuance of directives of Honorable Supreme Court in Kumari Madhuri Patil versus so-and-so, Office Member so-and-so has laid down the procedure for dealing with matters relating to fake certificates. Therefore, before any action is warranted against you, you are hereby given 2 weeks time from the date of receipt of the so-called notice to explain the reasons why which lead you to obtain a caste certificate of a caste to which you do not belong. In case no reply is obtained, necessary action as laid down in the OM will be initiated against you without any further notice. A copy of the inquiry report submitted by the inquiry officer is enclosed herewith for your ready reference. So this is the letter given to them. Now page 186. This is from the Home and Political Department, 3rd January. Initiation of departmental proceedings against Inspector Unarmed Branch, Dibbojyoti Datta, under suspension, so-and-so. With reference to the subject cited above, I am directed to inform you that Inspector Dibbojyoti Datta, officer in charge Digboi Police, is placed under suspension and a departmental proceeding is drawn up against him for his negligence and dereliction of duty in connection with perfunctory inquiry relating to verification of the caste certificate of an ALRS officer. A copy of the suspension order and departmental proceedings drawn up order is enclosed herewith in for favor of your kind perusal. And next page, on 29 December, the DGP issued this. Inspector Dibbojyoti Datta, officer in charge, Digboi Police Station, is placed under suspension with immediate effect for his negligence and dereliction of duty in connection with perfunctory inquiry relating to verification of the caste certificate of an ALRS officer during the period of service, he will gross substance, etc., etc. And page 187, a departmental proceeding is drawn up against Dibojyoti Datta for his negligence and dereliction. So the DGP of Assam has issued all these things. So the state has taken all the necessary steps as per law to protect the interest of the deprived class. And while doing so, Lordship, we have no other scope but to come before this honorable court seeking review of the order from the facts and from the materials which are placed in the review application, not only in the review application, but the additional affidavit, where the second CID inquiry report is also enclosed today, along with all the contemporaneous records and supporting records. So in that view of the matter, in my humble submission, it is a fit case for review, because a general caste candidate cannot take the benefit which is reserved from some deprived class like the OBC with non-creamy layer status. Here, prima facie, she belongs to the creamy layer. Father is a doctor, mother is an officer. Their income is much, much, much more. Now, the law on this will be BCCI versus Netaji Subhash case, the earlier day, Lordship, I have placed that paragraph. It is regarding on the law relating to review. 2005, 4 SCC page 741. Seven four one. The relevant paragraph will start from paragraph 89. '89, 90, 91, 92, 93, including 94 and 95. May I place this? Other day I placed only one single line. Today I like to place all these 4-5 paragraphs. Relevant page will be 764.
Which para?
Paragraph 89 onwards, Lordship. May I read it, Lordship? Order 47, Rule 1 of the Code provides for filing an application for review. Such an application for review would be maintainable not only upon discovery of a new and important piece of evidence. Here we are getting important piece of evidence also. Or when there exists an error apparent on the face of record, but it is also if the same is necessitated on account of some mistake or any other sufficient reason. In our case, there are two issues, Lordship, two facts on or two grounds. One is new facts have come into light. The other one is that subsequent developments. Thus, a mistake on the part of the court, which should include mistake in the nature of the undertaking, may also call for a review of the order. An application for review would also be maintainable if there exist sufficient reasons therefore. What would constitute sufficient reasons would depend upon the facts and circumstances of the case. The word sufficient reason in Order 47, Rule 1 of the Code are wide enough to include a misconception of fact or law by a court or even by an advocate. So here we can also harp upon misconception of the fact. An application for review may be necessitated by way of invoking the doctrine extra actus curiae neminam graviva. It is true that Moran so and so case, before going into the merit of the case, it is as well to bear in mind the scope of application of review, which has given rise to the present appeal. It is needless to emphasize that the scope of an application for review is as much more restricted than of an appeal. Under the provisions of Travancore Code of Civil Procedure, which is similar in terms to Order 47, Rule 1 of our Code of Civil Procedure 1908, the court of review has only a limited jurisdiction circumscribed by the definitive limits fixed by the language used therein. It may allow a review on 3 specified grounds: discovery of new and important matter or evidence which after exercise of due diligence was not within the applicant's knowledge or could not be produced by him at the time when decree was passed. So the government counsel who appeared at the time of before the division bench, Lordship, was not aware that the girl was staying with her parents. Mistake or error apparent on the face of the record and for any other sufficient reasons. It has been held by the judicial committee that the word any other sufficient reasons must mean a reason sufficient on ground, at least analogous to those specified in the rule, but the said rule is not universal. In Lily Thomas, the dictionary meaning of the word review is to act of the looking, offer something again with a view to correction or improvement. It cannot be denied that the review is a creation of a statute. This court in Patel Narsi Thakursi versus so-and-so held that the power of review is not an inherent power. It must be conferred by law either specifically or by necessary implication. The review is also not an appeal in disguise. It cannot be denied that the procedure of or technically of law cannot stand in the way of administration of justice. Law has to bend before justice. If the court finds that the error pointed out in the review petition was under a mistake and the earlier judgment would not have been passed, but for erroneous assumption which in fact did not exist, and its perpetuation shall result in miscarriage of justice, nothing would preclude the court from rectifying the error. Here the error was on us. We did not place the complete facts before the honorable court, and the person who is given the authority to place the facts, the fact-finding exercise, he did not disclose the complete facts, or he decided to give the facts which are beneficial to a particular person. It is also not correct to contend that the court, while exercising its review jurisdiction in any situation whatsoever, cannot take into consideration a subsequent event. This second inquiry is a subsequent event. In case of this nature, when the court accepts its own mistake in understanding the nature and purport of the undertaking given by the learned senior counsel appearing on behalf of the board and its correlation with as to what transpired the AGM of the board held on so-and-so, the subsequent may be consideration. Now coming to next paragraph, paragraph 94, I am reading from spectrum E, Court of Justice. Have Lordship got it? Next paragraph, in the middle portion, about 10 lines from bottom. Court of Justice may, when the compelling equities of a case oblige them, shape relief, cannot deny rights, to make them justly relevant to the updated circumstances. Here, the updated circumstances are before this honorable court now. I've got that updated circumstances. Where the relief is discretionary, court may exercise this jurisdiction to avoid injustice. Now, what will be the injustice if review is not done? The government is not going to lose anything. One post we have already given to one particular person. That person has taken a place which is reserved for another category of candidates. If a general candidate takes and occupies a place reserved for OBC candidate with non-creamy layer status, while allowing this particular writ petitioner to occupy that position, then one genuine OBC with non-creamy layer status will be deprived. That will be the injustice. So, Court of Justice may, when the compelling equities of a case oblige them to shape relief, cannot deny rights, the right of the person who is not before this court, to make them justly relevant to the updated circumstances. Where the relief is discretionary, court may exercise this jurisdiction to avoid injustice. So this is what we are humbly praying. Likewise, where the right of the remedy depends under the statute itself on the presence or absence of certain basic facts at the time of relief is to be ultimately granted. The court, even in appeal, can take note of such supervening facts with fundamental impact. This court judgment in Pasupati so-and-so read in these statutory settings falls into this category where a cause of action is deficient, but later events have made the deficiency, the court, in order to avoid multiplicity of litigations, permit amendment and continue the proceedings provided no prejudice is caused to the other side. All these are done only in exceptional situation and just cannot be done if the statute on which the legal proceedings is based inhabits by its scheme or otherwise. Such change in cause of action or relief, the primary concern of the court is to implement the justice of the legislation. Right vested by virtue of statute cannot be divested by this equitable doctrine. So these are the principles laid down in the judgment. There are a series of judgment on this line. So this is most relevant. That's why I place only one judgment. I think Dhanan issues is another judgment where the basis is this. Dhanan issued a division bench of this honorable court, where I was at the receiving end. 2008 5 GLR 489. Two 2008 5 GLR raised 459. Relevant paragraph. Paragraph 37.
459
459. I'm sorry, 459.
Mr. Saikia,
Lordship.
can you show us the previous report of the inspector?
Yes, Lordship. What does it put? Previous report. Previous report, it is quoted, Lordship.
But somehow,
The report, the relevant portion is quoted, Lordship, regarding Monsoon Borkakoti, his finding on Monsoon
the
Borkakoti.
petition, nobody has annexed it. Whether the government.
No, it was placed before the court. I am.
At the petition stage, it was not furnished to us. The learned additional advocate general were producing the record.
So it was in the record.
And same has been quoted in verbatim in the.
That we have seen in the last
Yes.
word. In fact, the inspector submitted reports of three particular candidates.
3 persons. One is Monsoon Borkakoti.
First one is the petition.
Lordship. At page 22, Lordship, that is the.
Running page 6 of the judgment.
Yes, running page 6. Here, Lordship will kindly see.
Kindly read that paragraph.
Yes, Lordship, I'll read.
And do.
In respect of Srimati Monsoon Borkakoti, I visited her parental house and present address Golaghat and Jorhat. In course of enquiry, it is found that father of the alleged, namely Sri Dr. Santanu Borkakoti, born and brought up at Silpukhuri. This again is incorrect. He was born in Golaghat and shifted to Guwahati. Anyway, maybe correct also. I am not. So no, he was. I'm sorry, Lordship. He was born and brought up in Silpukhuri. Followed the original rights, that is rights of Kolita community, and got appointment as medical officer. Was posted at Jorhat. The said doctor got married to a lady at Jorhat hailing from Koch OBC community and used to reside at matrimonial house, wherein alleged Miss Monsoon Borkakoti got birth at her mother's house on 12/4/1990, and since then she started her education at Jorhat and accepted customs of Koch community. During 2006, while she was the student of class 10, she applied for OBC caste certificate on the merit of her mother's custom. In fact, the father of the alleged though got appointed as MBBS doctor, however, he was not moved for OBC certificate as he was not from Koch community. It is pertinent to mention that in respect of issuing OBC certificate, Honorable Supreme Court passed a verdict referred to civil case number so and so, 18 January, and in connection with appeal, Honorable Supreme Court of India passed judgment that the child generally belongs to father's caste. However, child can claim mother's caste also in certain situations, and if the child is born and brought up at the house of her mother, who is ailing from other community than that of her father, it is a fact that the judgment promulgated not directly related to OBC community. However, the situation incorporated carried the ingredient for which the alleged Monsoon Borkakoti is seemed to entitled to obtaining OBC caste certificate. Moreover, the issuing agency clarified that the certificate is issued genuine and issued from the office. The photocopy of the OBC certificate issued by the President, All Assam Other Backward Classes Association, Guwahati. Copy of the certificate issued by local Gaon Bura, Digonto Borua, Sekonidhara Gaon, Moja, Jorhat East Revenue Circle, local Gaon Bura certificate issued by Torun Chandra Hajorika, Gaon Bura, Betioni, Golaghat. This Golaghat certificate is fake. And copy of judgment passed by the Honorable Supreme Court in connection with civil case number so and so are enclosed here as Annexure A. As such, it is established that the allegations brought against Sri Monsoon Borkakoti, daughter of Santanu Borkakoti, resident of Club Road, Jorhat, is based on no truth. The complainant perused only father's cause but did not go through the legal findings of Honorable Supreme Court. So he applied law of the Supreme Court without going to the complete facts. He was a fact-finding authority, rather he was applying law. So this is the opinion. That is why it was found to be perfunctory and he did not got into the depth of the matter. The relevant facts were not considered. Here he very cleverly wrote the word that Monsoon Borkakoti got birth at her mother's house on Sweden and started residing there. That mother's house is a parent's house here. So this is my case, Lordship. My humble submission is that Lordship may be pleased to, or Lordship was already pleased to admit, admit the review application. A notice was issued already, so I am praying for staying of the. Our basic ground is at ground A and B, page 12 and 13. May I read it, Lordship? The relevant paragraph. I'm sorry.
Just a minute. Do you have the copy of the read petition, read appeal? Read appeal.
Read appeal. Read appeal copy to us. I think we have.
Because it's a part of our record here.
It's a part of Lordship's record.
But
Maybe we have. Read appeal.
You have a copy of the read appeal. Or if you have the read petition.
Read petition.
Copy of the read petition. Do you have?
In fact, Lordship, read appeal was also not filed by us and none appeared. So if required Lordship, I can furnish it, Lordship.
There is something, that is why we want to be there.
Read petition of copy. I'll pull it automatically. Photo judgment you interpret for it. Yeah, pull it more.
Can I also go? Can I go to the?
It's a part of the record. It is a reply of the petitioner. Before the passing of the speaking order.
Yeah. In the SLC, my lord.
18/11/2020.
Before the SLC.
Before the assembly.
I want to reply to it.
Just I can read. The certain interesting aspects are there.
Lordship. This is what we found to be incorrect. Absolutely incorrect.
It is there, the straight, there are 3 pages reply, I believe.
Look.
3 or 4 pages reply. Yes, 3 pages reply.
Number one, all the নিজৰ ঘৰত আছে। এখন তোলাচোন কি
I've gone through it.
that inquiry report later be reviewed, huh? Subsequently, like, what they will. Review was based on the second.
The judgment of the Delhi High Court
Lordship.
was upheld by the apex court.
Hmm.
It was not upheld by the apex court. I remember.
Like it.
Review of Delhi High Court and judgment.
Today, I am not on whether she is entitled or she is
No,
not
no, no,
entitled.
we are
My
not-
humble submission is
not on-
at this stage,
No, you have something else to see. Just a minute.
Lordship.
Mr. Nath. Provide the judgment of the Honorable Apex Court reported in 2005 to SSC 244. No, 2012 3 SSC 400. Ramesh Bhai Dabhai Nakia.
In fact, that was relied upon by the division bench, in respect of which, my lord, now.
Only one thing.
Judgment.
You have the judgments are with you?
No, the order.
No, it is there. Now you just,
Read the
there are
judgment
reasons
I-
behind that.
Read the judgment again.
There are 54 and 55 of that particular.
Yes.
I'll-
তুমি কি সব অপরাধ আমরা করে সব দেখি তো সব ফেলে তো
Paragraph 2.
করা নাই
But it, read para 54 and 55
Yes.
slowly. It has something in it.
In view of the analysis of the earlier decisions and discussions made above, the legal position seems to emerge is that in an intercaste marriage or marriage between a tribal and non-tribal, the determination of the caste of the offspring is essentially a question of fact to be decided on the basis of the facts adduced in each case. The determination of caste of a person born of an intercaste marriage or marriage between a tribal and non-tribal cannot be determined in complete disregard of the attending facts of the case. In an intercaste marriage or marriage between a tribal and non-tribal, there may be presumptions that the child has the caste of the father. These presumptions may be stronger in the case where the intercaste marriage or marriage between a tribal and non-tribal, the husband belongs to a forward caste. But by no means the presumption is conclusive or irrebuttable, and it is open to the child of such marriage to lead evidence to show that he was brought up by the mother who belonged to the caste scheduled caste scheduled tribe. By virtue of being the son of a forward caste father, he did not have any advantageous start in life, but to the contrary, suffered the deprivations, indignities, humilities, and handicap like any other member of the community to which his or her mother belonged. Additionally, that he was always treated as a member of the community to which her mother belonged to, not only by that community, but by the people outside the community as well. This is a part of that notification also.
See, that is the reason whoever claims to be belongs to the mother.
Yes, now,
Have to lead the evidence.
yes, now,
Yes.
Now, here, that is the reason we have asked you to read the
yes, now,
annexure 14.
yes, now what are the attending facts? Now, what is deprivation?
That is not mentioned in her application. Number one, what we found from the record.
What is the deprivation? That deprivation, she has to say. If she can go to a missionary school in the heart of Jorhat city,
Not only that, the issue is that she was brought up by mother. That has to be there. But here is
the parents,
because in her representation before the committee, that's
Yes.
a particular this thing that she has mentioned. That is the reason we ask you to read that.
yes,
Here she particularly mentioned, if you see.
এখন আমার লগত নাই নেকি ৰেকৰ্ড এইখন তুমি ৰেকৰ্ডত আছিলা অৰিজিনেল ৰেকৰ্ডখিনি ৰাখিব লাগে না
আমি দেখার পর দেখাতে আরে সে তো নিজের হেৰি হৈ আছে ইনকুৱাৰী কৰিব নোৱাৰে
Subsequently, in the year 2009, I took admission for graduation at Cotton College
yes,
and completed my post-graduation from Cotton College State University in 2015. During my studies at Guwahati, I stayed at hostel.
hostel, that is an incorrect statement.
The community at large also recognized me.
That hostel is incorrect. She stayed in her father's house.
No, my lord, that's not correct. কিয় এটা OBC কি হোস্টেলত থাকিব কৰ্ম কৰিব নোৱাৰে নেকি
That is why the so-cause notice has been now issued. If she have to counter it that she was staying in hostel, she will have to give some evidence that she stayed in hostel, not at Silpuri. That is why the so-cause
No,
is
the thing here is what is missing in her representation is that she was
singly brought
by her mother.
mother. That is not
That
there.
is missing in her representation.
Exactly, Lord. And what deprivation?
No, maybe.
There is no deprivation.
She might have stated we are not on that, but there is absolutely no.
It will like
Yes.
This thing that Her father did not look after.
No, no, no.
That is not there. Anyway,
So Lordship may be pleased to stay at the issue notice and stay the proceeding.
My lord, no argument has been advanced on delay.
we have seen that.
My lord, normally, my lord, normally to make out a case of review, it should be a case of 5 minutes. When 1.5 hours is taken, it can be a case of review. Let us be very frank about it. Now, my lord, I'll explain the fallacy in the argument of the state. My lord, who can conduct an inquiry regarding the status of a caste? Who can conduct? Chief Minister? The DGP? No. It is only that committee envisaged by Madhuri Patel. And that committee has done it and that has found that I belong to OBC. End of the matter. If state is agreed by that, they should go to Supreme Court against the division bench order. My lord will kindly come to the judgment, my lord. Madhuri Patel's judgment. Now let us be very clear. My lord, yeah, I'll come to the second point, whether because of discovery of new facts, review lies or not, that I'll come second. First, let us see, my lord, whether Madhuri Patel or what is the procedure prescribed in Madhuri Patel is a complete code or not. If it is yes, then my lord, this second inquiry, third inquiry, or maybe 5 or 6 more inquiry may come. Nowadays, my lord, it has become fashion of the government of Assam, my lord, to make inquiry after inquiry. But please come to para 13 at page 254. Sub-para 5 at page 255. I think in the division bench judgment it is quoted. Yes, I'm sorry. Yes. Please come to the review petition, my lord. First of all, let us see whether the foundation on which the review petition seeks to stand, it has got any legs to stand or not. Please come to sub-para 5, my lord.
Of the judgment.
Yes. No. Paragraph 7, page 33.
The review petition.
The division bench has quoted it, my lord.
Yes.
Please come to my lord, sub-para 5. Each directorate should constitute a vigilance cell consisting of senior deputy superintendent of police in overall charge and such number of police inspectors to investigate into the social status claims. The inspector would go to the local place of residence and original place from which the candidate hails and usually resides, or in case of migration to the town or city, the place from which he originally hailed from. The vigilance officer should personally verify and collect all facts of the social status claimed by the candidate or the parent or guardian, as the case may be. He should also examine the school roll, birth registration, if any. He should also examine the parent, guardian, or the candidate in relation to their cases. Such other person who have knowledge of the social status of the candidate and then submit a report to the director together with all particulars as envisaged in the proforma, in particular of the scheduled tribe relating to their peculiar anthropological and ethnological traits, deity, rituals, customs, mode of marriage, death ceremonies, method of burial, etc., by the caste or tribe as the tribal community is concerned, etc. The director concerned on receipt of the report from the vigilance officer, if he found the claim for social status to be not genuine or doubtful or spurious or falsely or wrongly claimed, the director concerned should issue a show cause. So in case, my lord, the report of the inspector, who is the vigilance officer, is, my lord, against the issuance of that certificate, in which he will issue a show cause. Now, supposing the report is in favor of the candidate, please come to sub-para 7. In case the report is in favor of the candidate and found to be genuine and true, no further action need to be taken except where the report or particulars given are procured or found to be false or fraudulently obtained, and in the later event, the same procedure as is NVCS in para 6 to be followed. Assuming, my lord, it is incorrect, CM will not direct an inquiry. Another CID will not conduct that inquiry. It is that same vigilance officer who will conduct that inquiry. Where is that, my lord? Am I clear, my lord? The matter is very simple. My lord, I never said that my father is OBC. I do not know where from these documents are emerging, my lord. And my lord, the state has suppressed one fact. My lord, that deputy commissioner has subsequently issued a press release that the state has not disclosed. We have brought it in our affidavit. Now, therefore, my lord, Kumari Madhuri Patel is a complete code in itself. If there is any doubt about the caste certificate of anybody, whether he belongs to VC, whether he belongs to scheduled caste, whether he belongs to scheduled tribe, then it is this committee who will examine. No other committee can do, my lord.
No, Mr. Sorry,
Yes.
sir, that's absolutely correct. But thing is here,
Hmm.
the committee have set aside the certificate issued in favor of the petition,
Yes.
right? That's what you have challenged, that the petitioner have done.
Why?
And during that process,
Hmm.
there was in record placed before the court that the concerned investigating officer
Has given a favorable report.
and it was accepted by the Planet Single Judge, and accordingly the order of the committee was set aside.
Yes.
That means restoring the earlier certificate. Thereafter, though the state did not prefer any appeal, if that particular one complainant group preferred, the appeal was dismissed. And during that procedure, this judgment proper, where the paragraph 7 just now we have read. But it remains the fact that the committee found that the certificate obtained by the read petitioner, was not in a proper manner. That which the petitioner have challenged.
No, my lord. Question is, the moment vigilance officer's report is in favor of the candidate, this is not supposed to proceed. That's the view of the division bench. If it is wrong, then it's a province of appeal. It can't be a province of review, my lord.
That's true. That
Now,
means
if what has fallen from your lordship, if it is correct, then it is a province of SLP, not review jurisdiction. It has to be before a Supreme Court, not before this honorable court. That is not a case of review, my lord. That means there is an error in the judgment. That error can be corrected by an appellate court. Review jurisdiction, as the lordship knows, is very, very, very circumscribed. Now, my lord, please come to, now lordship is also conscious of the fact that there is a requirement that the committee or the vigilance officer must record a finding that he was born and brought up in the mother's culture, custom. That is there, my lord. Please come to page 31.
no, we are there. But thing is this,
Ah.
in those particular judgments cited by Honorable Division Bench here, it is very specific. It has to be by mother. There is a question here in the representation which is there at Nectar 14. The petitioner did not state anywhere that she has been looked after by only her mother. The only thing is that she stayed in her mother.
No, my lord, where from this only word has come, my lord?
No, she is there in the just read in the.
No, my lord. My lord, the fact of the matter is, because my father married it was an intercaste marriage, my mother was not accepted by my paternal grandmother.
Hmm.
That's why, my lord, my mother continued to stay in Jorhat, and I also stayed with her. And my father was in government service. He was in a transferable job. He was around. Only after retirement, because of the illness and all, my lord, we have got together. I never stayed in Guwahati in my father's place, my lord. I stayed in hostel. No, my lord, lordship is in review jurisdiction. Now, what is the scope of review? And there must be an error apparent on the face of the record, or some material which was obtaining as on the relevant date, that is 2006. This certificate was issued in 2006, not in 2019. Now, what is that material which they could not have placed, which now they want to place? Well, this inquiry after inquiry, Supreme Court has never permitted. Then lordship will be doing a roving inquiry, which is not permissible. In a review jurisdiction, how can your lordships go into all these aspects? Please come to page 31 for a moment, my lord.
31 of
The same review petition. I'll draw your lordship's attention to para 6. It would be apposite to mention here that during pendency of the appeal, and while considering the documents available on record, this court noticed that mother of the respondent writ petitioner, Srimati Purnima Dotto, was also serving in irrigation department. Thus, by order dated 21/2/23, the Learned Government Council was directed to produce service records of Purnima Dotto, which was presented for perusal of this court by Ardhar Learned Standing Council. On 28/2/23, a perusal thereof indicates that caste of Srimati Purnima Dotto is recorded as OBC course. In this background, the Learned Government Council was directed to bring this fact on record by way of an affidavit. An additional affidavit on behalf of the state was accordingly filed on 10/3/23, bringing on record the relevant document, including service book of Srimati Purnima Dotto. A perusal of the service book would reveal that date of birth of Srimati Purnima Dotto is 27/6/66, and she was included in the service as a master roll worker in the irrigation department in the year 1988, and her service were regularized in the year 2005. As per the detailed pro forma available at page 218 of the service book, the caste of the Purnima Dotto is recorded as on 8/6/2005 as post OBC. In this background, as person caste that the mother of the respondent procured caste certificate as OBC for the first time in the year 2019 is of no consequence whatsoever. Well, all these aspects were gone into. Anyway, my lord, I'll complete my submission on Monday, I think, my lord. Madam.
Question.
We'll take it up at 2 p.m.
Fine.
I'll come back for single.
It was not received. Value rejected by this honorable court, Lordship. Page 21 onwards. The rejection order.
Earlier application was rejected as because the investigation was at a very nascent stage. So updated case diary was called for.
Since CB was called for, Lordship, kindly give us the date so that we can produce the same on the next date, please.
Mr. D. Goswami, Learned Counsel appearing for the petition. Learned Edition Public Assam appearing. By orders dated 06/12/2023 and 21/12/2023. Up-to-date case diary pertaining to copy of the up-to-date case diary pertaining to Butterpur Police Station case number 97/2023, corresponding to special within bracket NTPS bracket close case number 34/2023 was called for. That is submitted by the Learned Public Prosecutor, Public Prosecutor. That case record, case diary is yet to be received. List on 23rd January for the up-to-date case diary pertaining to Butterpur PS case number 97/2023, corresponding to GR number 821/2023. There is a special NDPS case number 34/2023. Failure on the part of the concerned investigating officer to place the records of copy of up-to-date case diary of said Chatan court shall consider to pass consequential order against the hearing officer who is obstructing the adjudication of the matter. listed.
Obligation.